Yeah, it's gonna be hard.
Lots of people in here.
You wanna make it good up anyway.
Yeah.
Just listening. That night online and
Please rise.
Please be seated, everyone. Welcome back. Now, here are the closing comments from the prosecutor.
The defense counsel said in his opening remarks that I was telling people that there's no bad guys out there. There's no reason for you to lock your doors. I've been prosecuted for 20 years. That's the last thing in the world I would tell somebody, because there are a lot of bad guys out there. But the reality of the situation is, if you're a woman, if you're a child, there's a good guy going, the bad guy lives in your house. And that's what the situation is here. The first thing I want to point your attention to is the morning of Tuesday, October the 13th, 2015. And I'm going to specifically ask you to look at the time period of 6:40 a.m. Because at that point, there was a full-blown crisis unfolding on Cooper Street in Haddon Township. 911 had been called. The Haddon Township Police Department was there. The Westmont Fire Department was there. Police from neighboring communities like Collingswood and Audubon were all there. If you recall the testimony of Chief James Jankowski, he was on his way. He had already ordered a mobile command center to that location. Almost all the family members that have been here throughout this trial, both the Creatos and the Donatos, they were all out there. The neighbors were coming out. And the bottom line is that this whole community was coming together because they had been told that a child was missing. And what was the defendant doing in the midst of this at 6:40 a.m.? He's checking Julie's Snapchat account. 33 minutes after he called 911, when everyone was coming out and coming together, he's looking at her Snapchat account. Now, given some of the hateful things that Julie said to the defendant over the course of this 4-month relationship, it was only 4 months long. Probably everyone in the room would agree that she is a foul and nasty teenager. No question about it. But not in his eyes. To him, she was amazing. She was beautiful. She was the best girlfriend in the world. That's what he said to her. This defendant was obsessed with Julie. He was utterly consumed by the idea that she was talking to other guys. And he was utterly consumed by the idea that she was leaving him, that she was dumping him. And that is one of several reasons why he killed his son. And Brendan's death was a homicide, make no mistake about it. The first thing I want to talk to you about is why it was a homicide. You heard testimony from the doctors in this case. In its simplest terms, the determination is a process of elimination. You've got suicide, you've got natural, you've got accidental, and you've also got homicide. Probably one of the first things that we can agree to is that this was definitely not a suicide. That one's easy. But let's talk about a natural death, okay? Because you heard testimony from Brendan's pediatrician, remember Dr. Stephanie Schlitt? She testified, and she had taken care of Brendan from the time he was just a month old. She said that in March of 2015, Brendan was diagnosed with asthma. It was initially noted to be just mild and intermittent. He had a few flare-ups, though, and so his diagnosis was then changed to mild, but persistent, but still mild. The flare-ups were usually caused by colds, but it was well controlled with his medication. There were no signs of asthma during the post-mortem examinations, and that's a key fact here. All three medical examiners agreed. If a person suffers an asthma attack, there will be mucus plugs in their lungs. If they suffer a fatal asthma attack, you would be able to see the mucus plugs in your lungs with your bare eye. You wouldn't even need a microscope to do that. But in this case, even microscopically, there was no evidence of the telltale mucus plugs of an asthma attack. Now, Dr. Schlitt said she last saw Brendan on September the 28th of 2015. That was approximately just 2 weeks before he died. Sam brought him in at that time to see her because he'd been having some behavioral issues in school with kicking and biting some friends. And do you remember what Sam said about that, how she explained that? She said he liked to pretend like he was the Hulk. And that's what she attributed his behavior to. It's good to note that all his behavioral issues were at school. There were no issues at home. He was fine at home, except sometimes he had trouble sleeping. And Dr. Schlitt thought that might be due to his asthma medication, which was albuterol. So at that last visit, she changed it to levalbuterol, which is supposed to have less side effects. Brendan was not diabetic. Brendan did not show any signs of lead poisoning or any of the other what-ifs that you heard questions about during the course of this trial. What she did say about him was that Brendan's growth, his development, his speech, his gross motor skills were all right on target for his age. He was a perfectly normal little boy. And she also said that he was thriving and healthy. This was not a natural death, okay? That much is clear. So that's going to bring us to accidental deaths. What is an accidental death? I'm sorry, I'm going to stand in front of you. If Brendan had wandered out of the defendant's apartment to Cooper River, fallen in the water and drowned, obviously that would be an accident. But we know that that is not what happened here. We know that first of all, because the defendant himself says Brendan did not leave the apartment by himself. And listen to this clip. He said he's never once gone to that door, ever. He also mentions that Brendan is afraid of the dark.
I wouldn't see him going up door.
Not only did the defendant tell the police that, but Lisa Creato told you that when she took the stand, the defendant's mother, Brendan's grandmother. She said that he would not leave by himself and that he was afraid of the dark. Sam told you that he was afraid of the dark. Most 3-year-old kids are afraid of the dark. I would suggest to you as well that another reason we know this is not accidental is because even though Brendan could open the door, it's hard to imagine he could get out the door by himself. He might have been able to unlock it, but do you remember what Sergeant Lance Saunders said about the exterior door to the apartment building? He said it was very heavy, it had some weight to it, so much so that he noticed it when he walked into the door. You have to pull that bottom door out to get inside, if you recall. You can tell by the way it's being held open there. And you also heard from the property manager, Greg Filosa, that both the interior and exterior, the upstairs and the downstairs doors, they're both on loaded spring hinges, which means that they close themselves. You can see that the door there has to be propped open. Now, Julie testified that she was awake at night. If she was awake at night, she could actually hear Brendan breathing in the next room, if you recall that testimony. She said sometimes when he was breathing, it would sound like it was a little snore. So it stands to reason that if Brendan left the apartment on his own with the spring-loaded door, that surely the defendant would have heard the door closing itself behind him, because that's going to make some noise. It's a heavy door. The defendant sleeps, I think the testimony from Detective Gersick was 11 feet away from the front door, because that's how tiny that apartment is. He's right there. That is something that he would have heard. And tuck that thought away for a minute, because we're going to see some video of that. And we'll come back to that. Another reason I say Brendan's death was not accidental is because of the location where he was found. Now you recall this. This is the map that Officer Nicholson testified to, that was the route that her dog took when they were out searching for Brendan. You may recall that Brendan was posed in the creek as though he had washed up there, which is just ridiculous and completely unreasonable, because you don't wash up in a creek that's 6 inches deep, first of all. And second of all, that was why you heard the testimony from John Wallock, who was the supervisor of parks, about the dam. He explained to you that there is no tide in Cooper River in Westmont due to the fact that there is a dam further down in the city of Camden. So there's no tide there. Nobody's washing up anywhere. But that's the way his body was posed to look like. That creek is 3/4 of a mile away from the defendant's apartment. Brendan did not, under any circumstances, make that walk alone in the dark. You all made that walk. At least you made the last quarter mile part of it. You didn't walk from the apartment building all the way down to the park. That's the first half mile. You all walked the rest of it, and the reason that you did that is so that you could better understand what is involved to get down to the location where he was found. You walk through the park, then you go through that first little wooded area. Can I have lights, please? Yep. Thank you. So you're gonna walk through the park. You're gonna walk along the trail, then you're gonna go through this wooded area, and that wooded area is going to bring you out to that big open field that you saw. And all the way over there by that, I believe the testimony was it's a vent pole, is where that path is located. Then down the hill to the bottom where the creek is, and then you had to make a left, and you go all the way where that fallen tree is, and there's the close-up shot of the tree behind which Brendan was found. That's a long way. That's way too far for a 3-year-old to make that walk. There is no way that he did that on his own. And remember, too, Brendan had never been to that part of the park. Do you remember when there was testimony about the statement that the defendant gave, and they actually gave him a map and said, show us which part of the park you take your son to? And this is where he takes his son. They just go straight down Cooper Street, and there's a big open field here. That's not where Brendan was found. Brendan was found, remember you had to walk down South Park Drive and go off into the woods over here. Brendan had never been to that location before. It's not really the kind of location you take a child anyway. But he had no familiarity with it. Now, you recall the night video when we filmed it that night. It was less than 24 hours after Brendan was found. 4 adults could not locate the path to the water without the use of a flashlight, is what the testimony was. Of course, those 4 adults, including me, are not familiar with those woods. But the defendant is. He's very familiar with those woods. Just because we needed a flashlight to get out there certainly doesn't mean that he would. This is from his consensual with Samantha.
Before I even knew where he was found, I was telling the detectives that was my favorite place in Hyde Township, and I love to go there, and I go there all the time. And then they told me that they found him there, and I'm like, what's the talking about?
It's his favorite place in Hyde Township. He loves to go there. He goes there all the time. Those are his words. He could probably get down there blindfolded. It's a little bit difficult for everybody else, and it's impossible for a 3-year-old. And we know he does it at night.
I've walked through everything was 2 o'clock in the morning before, with my friends, I can't do that far.
He's walked walk through the woods at 2 o'clock, 3 o'clock in the morning with his friends. He's very familiar with it out there in the dark. And the other reason we know that Brendan didn't walk there is because of his socks. You hear a lot of testimony about socks. Clean socks, that's what it was all about. Because if Brendan had walked down there, certainly his socks would be dirty. This is what Brendan's socks looked like once, as soon as he was pulled out of the water. This is what they looked like after they dried. This is what Sergeant Norcross's socks looked like after he made the walk at night. This is what the 3-year-old socks looked like, the little girl that made the walk for us. And do you recall some of the pictures that you saw of the little 3-year-old girl making the walk, how all during the walk she's holding Captain Telane's hand, but then once they enter into the woods, she doesn't want to hold Captain Telane's hand anymore, she wants to hold her mom's hand now. And that's in broad daylight. So let's look at Brendan's socks next to the experimental socks that that little girl wore. But that's not necessarily an accurate comparison, because you saw the socks, and I think it's fair to say that they all look better once they're dry. They don't quite look as dark. But the really fair thing to do is compare them when they're wet, because Brendan's socks were definitely wet when he was found. There's just no comparison there. It was suggested during the trial that the experimental socks were more beat up because they were worn on the outside of the shoe. But the testimony you heard from Captain Telane and Detective Delano, I believe, was that they noticed that the little girl was shuffling her feet as she walked along, as a lot of little kids do. I don't think that's necessarily a dispute. Now, the other issue that was raised, that was insinuated by the defense, was that maybe Brendan had other unaccounted footwear that, you know, the prosecutor's office couldn't locate because we didn't dredge or scuba dive in 6 inches of water where Brendan was found. All of this child's footwear is accounted for, and you know that. Think of the testimony that Lisa Creato gave you. All of Brendan's toys, well, most of Brendan's toys and Brendan's clothes are kept at her house, right around the corner, where Brendan also had a real bed in a real bedroom with a nightlight and everything else a 3-year-old might need to be comfortable and feel at home. The testimony was that Sarah, the defendant's sister, gave Brendan a bath that night, and she put him in brand new pajamas that his grandma had just bought, put him in his socks and his Mickey Mouse slippers. Lisa Creato, meanwhile, put together a little outfit for Brendan to wear to school the next day, including his sneakers. See, it was all folded up right here in a nice tidy pile where she left it for him. There's his sneakers. We know what happened to his slippers. One of them was left on the living room floor where he took it off, and the other one was used to find his body in the creek. All of his footwear is accounted for. He doesn't keep things in his dad's house. It's not Brendan's house. It's his dad's house. Even the defendant, during the course of his statement, despite the way he initially reported this, even he admits it wasn't at all.
Because I don't see him just walking out the door and just leaving and going all the way down the Cooper. That sounds so unlikely to me. The fact that he ended up down the Cooper is blowing my mind. Like, I don't understand. For one, it's out of character for him to leave my apartment. For two, for him to end up down there, it doesn't add up in my head. I don't understand. And I feel like that's where there's something wrong. I feel like maybe somebody came in my apartment. I don't understand.
We'll get to maybe somebody came to his apartment in a minute, but I think that everybody can absolutely agree that it's simply not reasonable to think that Brendan's death was in any way accidental. And that leaves us with homicide. In this case, you heard from 3 different medical examiners, each of whom performed a post-mortem examination on Brendan. Alex, please. The first of those examinations came on Tuesday, October the 13th, the very same day that he was found. was performed by Dr. Gerald Feigen. Dr. Feigen is the medical examiner for Camden, Gloucester, and Salem counties. He's been licensed since 1982. He's been doing this for 35 years. He has performed a very high number of autopsies, which is due in part to his 28 years of service in the military, where he was the regional military medical examiner for this area, which includes Dover Air Force Base. He performed the first examination within hours of Brenda being found. He observed flattening of the gyri, which was noted and documented, and he explained that flattening of the brain in that manner indicates someone was deprived of oxygen. It's a lack of oxygen that caused it. The next day, which was Wednesday the 14th, Dr. Feigen called for a second look at Brendan. And this time, he noted and documented 2 parallel contusions or bruises on Brendan's right clavicle area, right near his collarbone. He removed the contusions for the purpose of conducting microscopic testing to look for signs of inflammation, because remember, he said inflammation. The first signs of inflammation are a sign of healing, or that the healing process had begun. Dr. Feigen was, I'll say, questioned by Mr. Ficino during his cross-examination. But really, what it amounted to, a lot of it, was quibbling over trivial matters. And, you know, let me back up a little bit. Is it really reasonable to doubt Dr. Feigen's conclusions because there was a handwritten report prepared by a medical examiner's investigator pertaining to an unrelated case that was attached to the back of his report? Who cares? The testimony there was very clean, very clear. Mr. Ficino said to him, "What did you review before you came in to testify?" He said, "I reviewed my report and I reviewed the toxicology report." He even actually asked him, "Did you review any handwritten notes or reports?" And he said, "No, I did not." The medical examiner's investigator report that obviously did not belong attached to those papers was a handwritten document. So that's really no reason to question 35 years of experience. It's more like it's a clerical error. It's insignificant. It means nothing to this case. It should not be the deal breaker on whether or not you find Dr. Feigen credible. But even if it is, even if that's too much, you did hear from 2 other doctors. Because on Thursday, October the 15th, Brendan then had a second post-mortem examination, this one conducted by Dr. Charles Siebert. Dr. Siebert is the assistant medical examiner for Camden County. He's been licensed since 1995. He's been doing this for 22 years. And he was called in by Dr. Feigen. Doctors can do that. They can get second opinions, have people come in, make sure they didn't miss anything. That's the proper way to do it. Now, the defense offered to stipulate to Dr. Siebert's expertise in his field, but I wanted you to hear the extent of his experience because I'm going to ask you to rely on his opinion when you're making your findings. And it was his opinion, after conducting his own examination of Brendan and reviewing the test results and looking at the microscopic slides, it was his opinion, to a reasonable degree of medical certainty, that Brendan's death, the manner of Brendan's death, was a homicide, and that the cause of his death was homicidal violence, not otherwise specified. But that's not where it ends, because the next day, Friday, October the 16th, Dr. Andrew Falzon, who's the chief medical for the entire state of New Jersey, he performed a third autopsy. And Dr. Falzon's been doing this since 1986, so 31 years. He's licensed in 5 states, as well as Great Britain, and I believe he said Malta. Again, he was called in by Dr. Feigen, and again, the defense offered to stipulate to his qualifications, but I didn't want to do that because I wanted you to understand how experienced he is, because I'm going to ask you to rely on his opinion in making the findings. And it was during his third examination that Dr. Falzon made note of a single petechia in each eye. He noted a bite mark inside Brendan's left cheek, which is the same cheek that was laying on the ground, when he was laying on the rock rather, when he was found in the water. And both of those injuries, all 3 of those injuries, I guess, were documented because they were observed, and that's what they do. They document what they observe. It was Dr. Falzon's opinion, after conducting his own examination and his own personal examination of Brendan, and reviewing test results, and looking at all the microscopic slides, and reviewing the investigative file, that the manner of Brendan's death was a homicide, and it was further his opinion, to a reasonable degree of medical certainty, that the cause of Brendan's death was homicidal violence of undetermined etiology. That's exactly what Dr. Feigen said. Counsel wanted to know what the big difference was and why Dr. Falzon changed his opinion. Dr. Falzon never changed his opinion. Dr. Falzon, back in November of 2015, simply wrote a letter to the prosecutor's office that indicated that a further investigation would be warranted before he would make any findings. And then he did that. He was provided with the investigative file, and he reviewed it. He listed everything for you that he reviewed, and at that point, issued an opinion. So he never actually changed his opinion. Green lights, please. Oops, I'm sorry, I made misspoke. That's okay. Daniel, can you do that? The three people that you heard from are all medical examiners currently employed by the state of New Jersey. And I've already mentioned this. This is how many years they've been doing this. You know that altogether that's more than 88 years of combined experience in anatomical, clinical, and forensic pathology. That's an incredible amount of experience, and they all agree. Between them, they have more than 30,000 combined post-mortem examinations that they have performed. They know what they're doing. They all concluded that Brendan's death was a homicide. That is a homicide. That is what the homicide trial looks like. There should be no question in anyone's mind that that was not an accident, that was not natural, it's not suicide, it's a homicide. All three doctors relied on the fact that Brendan's socks were clean. But that's okay, because they were clean. Doctors have to look at the facts too, not just the medical things that they see. They were each asked a hypothetical question. What if Brendan was found on the couch that was supposed to be his bed? If he was found on the couch, would that change your findings? Well, of course it would. Of course it would. But it doesn't matter, because he wasn't found on the couch. He was found in that creek. They were also asked, would you change your opinion if he lived across the street from the creek as compared to 3/4 of a mile away? Well, it might. Of course it might. But it doesn't matter, because he didn't live right across the street from the creek. He lived 3/4 of a mile away from it. Do people move bodies after they're dead? Sure, I'm sure they do. Usually after they kill them. Do people move bodies regularly? No. It's just not reasonable to think that that would actually occur. One of the points that Mr. Ficino makes is that is with regard to taking some additional swabs during the course of the autopsy. Now, the testimony was that anal swabs were not taken because they were not indicated, because you're not going to sexually assault a 3-year-old in their genital area and not leave any marks of physical injury. So it's not reasonable to believe or even suspect that Brendan was sexually assaulted in this case. He just wasn't. There's no evidence of it. And not only did Dr. Feigen not think anal swabs were necessary, neither did Dr. Siebert or Dr. Falzon. 88 years worth of experience did not think that this child was sexually assaulted. And not one of them took oral swabs either. Again, not indicated. Are you going to believe that someone forced Brendan to perform oral sex on him? On them? On this mystery person? What would the basis for that belief be? Because even the worst pedophile on the loose out there would not try to force his penis into the mouth of a child that he doesn't know, because that's a pretty good way to get a serious and painful bite. That's not the way these things work. No one would do that. It's not reasonable. There were other things that all the doctors were asked about. Did they test his sugar levels? Did they test his lead levels? No, he's not a diabetic. He doesn't have any signs of lead poisoning. He wasn't suffering from any of those things. And there were a lot of questions about testing the pajamas as well. But again, it's for what? They were examined, they were dried, they were photographed, they were examined. There were no hairs, there were no fibers. Christina Nipper from the New Jersey State Police Forensic Lab explained that trace evidence, when it is found, is really only testable when you have something else to compare it with. There's nothing else to compare it with. I feel like I saw a TV show a long time ago where somebody gets some fibers off and they put it in this machine and it spits out a piece of paper that says this is from a carpet that was sold by IKEA in 1984. That's not the way this stuff works. You have to have a sample and you have to have a comparison. There is no comparison in this case. And quite frankly, there's not going to be anything on the pajamas either. Brendan was submerged in water for hours, many hours. I mean, it took 3 hours to find him after 911 was called, almost 3 hours. He was in the water for so long that Detective Ellis testified when he got in and had to lift him out of the water that rigor mortis had already set in. And you can tell from the silt lines that were on his face that he was completely submerged at one point, probably all the way up until they opened up the dam that night. And I'm going to ask you to think about this in the context and compare it to the stroller that was collected from the vacant house. And by the way, you did hear testimony. That man was interviewed. Detective Rhodes testified about it. The man that said he saw somebody with a stroller said he saw him over half a mile away and not walking away from the river, walking towards it. I went through all the maps that we used throughout the course of this trial. The place where that guy said he saw him is so far away that I couldn't even find it on any of the maps. But it was reported, so the stroller was collected, and the stroller was submitted to the lab because that might give us a comparison evidence. But of course it didn't. You might expect to get some DNA off the handles of the stroller. That would actually be a good place to get it because the person pushing it has to actually grab onto it, hold onto it. They might leave something behind, but there was none. So I want you to think about the fact that the stroller was collected on October the 28th, 2015. I think the testimony was that it was around 6 o'clock at night. Now that's the same day that the experimental socks were soaked in the water in the creek. And you remember there was that huge rainstorm and that tiny little creek looked like a washing machine that afternoon? The stroller was sitting outside during that. It poured. And the point there is just to say that it's water washes away biological stains. It does. That's why there's nothing on the stroller. All right, now, I don't want to keep talking about the never-ending and sometimes irrelevant list of what-ifs. So let's take a look at what we actually have in the form of evidence in this case. And the direct evidence, the evidence of injury, there is not much, but that in and of itself is telling because 88 years of forensic experience told you that smothering leaves little or no evidence behind. So you know, we have flattening of the gyri. The brain is not as distinct as it would normally be. And according to all 3 doctors, that's consistent with smothering. We had some very minor petechia in both eyes. There was one spot here, and one spot here. And again, it doesn't mean he was suffocated, but it is consistent with him being suffocated, with him being smothered. I would suggest to you that the bite mark inside of his mouth is also consistent with being smothered, especially if he woke up. The victim in this case is 3 years old, and the testimony you heard from the state medical examiner was that as compared with trying to smother an adult, it would be much easier to smother a small child like Brendan was. You also heard testimony from Dr. Falzon that it would be much easier to smother a person who is sleeping like Brendan was. And this little boy had on his collarbone 2 bruises. You saw pictures of these before. And when you look at these photographs and you imagine that he's laying on the couch and he's sleeping, how could you get those bruises within an hour of your death? And it's very simple. It would just be your hand, holding them down. And putting his pillow over his face with the other hand. Based on the microscopic evidence, the microscopic exam, and according to Dr. Siebert, those bruises were inflicted within an hour of his death. There's no bruising on his face, not even in the deepest tissues, which according to Dr. Falzon may indicate that smothering was accomplished with a pillow or another soft object. And that's interesting, because this defendant, the person who unquestionably had the motive, the opportunity, and the means to kill Brendan, he cannot stop talking about Brendan's pillow. This is from his statement to Detective Rhodes on October 13th. He says, I gave him a pillow. He said, no, I don't want it. So I took his pillow and I put it to the side.
I said, no, it's time to go to bed. And he put it to the side. I didn't know. I gave him a pillow. He said, no, I don't want it. And I took his pillow and I put it on the side. So I gave him his blanket.
Later during the same statement, when he was asked about where Brendan sleeps, again, he brings up the pillow.
I said, no, it's time to go to bed. And he put it to the side. I didn't know. I gave him a pillow. He said, no, I don't want it. And I took his pillow and I put it on the side. So I gave him his blanket.
I'm sorry, I think I skipped back and very eventually asked. This is the second clip.
Back to when you finished your son's listening, okay? Now, he says he sleeps on the couch. Is there a pillow, blanket? What did we have there for?
No, there was a pillow and a blanket. He said he didn't want the pillow. I put the pillow to the side. He just had a blanket.
And that's not the last time he says it, because he mentioned it to Sam, too.
Yeah, he went to bed. He didn't really have a problem going to bed. He lay down. He asked for water. He was sippy cup. He had sippy cup. Didn't have those down. He didn't want the pillow, so I put the pillow up on the side, and then he had a blanket on that. I went back to his room and said, I didn't want to be.
The only thing that I have to prove to you is that the defendant purposely or knowingly caused the death of his son. I think that's been done. I don't have to prove when. It's not one of the elements. I don't have to prove where. That's not one of the elements. I don't even have to prove how. That's not an element. Listen for that when the judge is giving you your instructions. I want you to think logically and think reasonably and use your simple common sense and see how all the evidence in this case indicates that sometime after 1:27 a.m., after spending the day, and we'll get to what happened on that day, but after spending the day hassling Julie repeatedly about who she's with and what she's doing, and after spending the evening blowing up her cell phone, and after spending the late night and early morning hours obsessing over her Snapchat account, this defendant got out of his bed, went in the living room, took Brendan's pillow and put it over his face while he was sleeping. And he held it there until Brendan died. That scenario fits with the flattened gyri, with the 2 parallel bruises on his clavicle, and even with that little scritchy mark on his neck. It fits with the utter lack of any other kind of injury. And when it was over, the defendant took Brendan's body and laid him in the water of his favorite place in Haddon Township, a place where, in his view, there's special energy. And that's where he put his boy. And he put him there because he wanted him found. He didn't want him to be lost forever. He is so carefully laid there, and he does appear to have been lowered into the water in his pajamas. concluded that was a homicide. The next question is, well, who did it? Who could possibly be the person who did that? So the first issue would be, was it a stranger? I don't think so, and here's why. Why would a stranger take Brendan? The obvious answer would be to sexually assault him, because isn't that why most children are abducted? By strangers. But Brendan wasn't sexually assaulted. He had no injuries whatsoever to any part of his genitals. Not even a sign of the slightest hemorrhage in the deepest tissues of his buttocks, which was carefully examined. He didn't have any bruising other than the clavicle on his neck to indicate that he was grabbed by his arm, that he was pulled, anything. There are no other injuries. How would a stranger even know Brendan was there at his father's house? That baby slept at 3 different houses, and it depended on the night and who was where. You would never know when he was actually going to be laying on his father's couch. He's supposed to be there certain nights, but the defendant takes every opportunity he can to unload him on someone else. This particular weekend, he should have been there for 4 nights. He was there for 1, I think. I think it stands to reason that Brendan would have fought back if a stranger came into his apartment and tried to get him. Remember what Sam said about him getting in trouble in school, that he liked to pretend he was the Hulk. The Hulk is not leaving the apartment in the middle of the night with a stranger quietly. That's just not going to happen. He's going to fight back, and surely that would wake up the defendant, who was only 11 feet away. How would a stranger get into the apartment? And this is what brings us up to all the conversations that there were about the doors. And this is very interesting. Both the defendant and both of his parents have worked very hard to convince the police that something was wrong, first with the exterior door that was located downstairs, and then later on, much later, with the second door to the defendant's apartment that was located upstairs. Now that's a tall order, though, because on the defendant said on the 911 call, not once but twice, that the doors were locked. He said both doors were locked. Do you recall what Lisa Creato said when she testified about the doors? We were discussing the bottom door, and she said, I locked the door, and then without me questioning her, she added, but I didn't check it. Well, that's not true. You remember I had to show her statement that she gave to the police back in October? I showed her the transcript in which she clearly told Detective Rhodes she had checked the door, and she was sure it was locked when she left, because she checked it. Those were her words at the time. So let's do a timeline. And while we're talking about it, please keep in mind that the defendant and his father install doors and windows for a living. It's what they do. It's how they make their money. This is a photograph of the apartment door, the inside of the upstairs door, okay? This photograph was taken on October 13th, 2015 by Detective Gersick at the time that he searched the house. We know that, let me back that up. Here's all the information we have about the doors from October the 13th. Early that morning, between 8 and 9 a.m., Sergeant Lance Saunders arrived on the scene, and he was there on behalf of the CART team, the Child Abduction Response Team. He asked the defendant for permission to search his apartment, and they executed a written consent. Now, Sergeant Saunders made note of 3 things on his way into that apartment. Number 1, there were no signs of forced entry. Number 2, he testified that the defendant used keys to open both the bottom door and the top door that led directly to his apartment. And the 3rd thing he noted was that the exterior door, the downstairs door, was heavy. I believe his words were, it had some weight to it. Now later that same day, still on Tuesday, in the afternoon, crime scene investigative detective Joe Gersick came in to search and process the apartment. He also noted that there were no signs of forced injury, and he noted that the doors had to be propped open in order to stay open. And his testimony to you was that when he was done taking all his pictures and collecting everything that he needed to collect, he secured the apartment when he left by turning the button lock on the knob and pulling the door shut. His testimony was that he did this for both doors, the upstairs door and the downstairs door. And we always do this. We never leave property unsecured after executing a search warrant. Never, ever. We're responsible for the property. Property has to be secured. If it can't be secured, the local police department is going to be called up to handle it. Those doors were locked. Now let's jump ahead a little bit to October the 15th. This was Thursday, and remember, Detective Gersick is back at the apartment, this time looking for a suitcase, because we haven't found the suitcase guy at this point. He took some more photographs, he collected some items, including 2 pillows and that suitcase. And he, again, his testimony was, he secured the apartment when he left by locking both doors. Now, a full week after Brendan was killed, on Tuesday, October the 20th, the defendant's father called Greg Filosa, the property manager, and he wanted to report that the door to the apartment was broken and the latch in it wouldn't catch. And you heard from Gregory Filosa, he's the property management. He said he was notified on the 20th, a week after Brendan's death, by the defendant's father, that he went out there to look at this, and then he made this video on Saturday, October the 24th. Now you can see from that video that the latch isn't catching. You can just push the door open without turning the doorknob at all. If that was the case when Detective Gersick was there, he would not have been able to lock the door. I want to play that for you one more time, just because I want you to listen to the noise that it makes. Remember I indicated earlier if Brendan had wandered out of the house on his own, the door closing would probably have woken his father up. This door makes noise, and Greg Filosa looks like he's opening about an inch. Imagine if that was open far enough for a person to walk out at how loud it would be. The next thing that Greg Filosa did after making this video and checking it out is what any normal person would do. And that is, he notified the Haddon Township Police Department that there was a problem with the door. That the child, from the child's apartment. You know, the fact that this was reported, or the fact that that the landlord or the property manager was notified of this on October 20th is a little bit interesting. Because if you recall, that was just the day before Mr. and Mrs. Creato finally came into the prosecutor's office to get a statement, more than a week after the grandson had died. And I believe defense counsel in his closing indicated that we didn't take a statement from Sarah, the defendant's sister. I believe the testimony was she, like her parents, refused to speak to us. It's not that we don't want to take a statement from her. We can't force people to get the statements. Now, because Mr. Filosa did the proper thing and notified the police department that there might be an issue at the door, the police went out there with him on November the 6th. He consented to a search and photographs, and the door was again photographed. And you can see, this is the photograph, this is the zoom in of it. You can see that the latch is not engaged. There is a space there, that's kind of obvious. But the better comparison is when you look at them side by side. Because here on October 13th, it's clearly engaged. Here on November the 6th, it's not. And for a point of reference, you can use the little paint chip, because you can see the little paint chip on the door here is about 1/3 of the way up that latch. Here, where the door now won't close, it's more than halfway up in the latch. Somebody tampered with that door. But they didn't do it before Brendan got killed. They did it after Brendan got killed. That happened sometime after October 15th. I don't know when it was done exactly. Well, like I said, it was definitely after the 15th. I don't know who did it, but I know the defendant would know how to. I do, however, know why they did it. Because the Brendan wandered away story wasn't selling anymore. So now we needed to have a stranger kind of a story, something else in the mix to make all this fun. And there might even be another reason. Let me back up a little bit. As far as the door, the latch being broken, This is the statement that the defendant gave on the 13th. This probably would have been a good time to mention that the door was broken.
Did you really top the steps?
If it was.
It was locked. I can't remember if it was locked. It was shut, yes. Feeling there was a deadbolt. I can't be certain if I did the deadbolt or not.
And when you say you can't be certain if you did the deadbolt, you're talking about the top of the steps.
Yeah, top of the steps.
And that immediately leads into your living area.
Yes.
The door at the bottom of the steps is a common entryway or
We just talked about the door. Was the door locked? I don't know if it was locked. Was it shut? Yes, it was shut. Oh, it was shut, but by the way, it doesn't latch, right? Wouldn't that be a normal and natural thing to say if that was the case? But he never does. They go on and talk about the door for 15 or 20 more seconds. He never mentions that the door is broken. And then there's always this angle. You remember this from the consensual, when he was talking to Sam about the door being broken.
It's so easy to break into that apartment, it's not even funny. Literally every time, like, I don't even use the keys to my apartment, I don't even have them. I leave them in the apartment, I'll just break in every time I go to that apartment. Like, literally.
You can break in that front door?
That's how I always got in, I never even had my keys.
That's terrible.
It's literally not easy to break into that apartment. It's not safe, my room was even talking about maybe, looking at people I can see around for all these over with. Like, we'll get, like, sort of a landlord and making it a not secure place, or...
I'm going to sue the landlord. The apartment was brand new when he moved in. He was the first tenant after they spent $100,000 renovating their building. I'm going to sue the landlord. After all this is over with, what does that mean? And there's another reason why I say the stranger did not kill Brendan. And this is the biggest one. How would a stranger know where to put Brendan's body? How would a stranger steal a child or find a child on the street and grab him and kill him? How would that child end up in his favorite place in Haddon Township? That is not possible. A stranger who stole Brendan would have just made him disappear. That would be so much easier. Or maybe even put him in the river, hoping that he would go downstream. But not in that creek. No way. Not in the defendant's favorite place in Haddon Township.
And the detectives also, before I even knew where he was found, I was telling the detectives that that was my favorite place in Haddon Township, and I would do that, and I go there all the time. And then they told me that they found him there. What they're talking about.
So it is his favorite place. And of course, it is an area where he finds there would be a very special...
I don't want to sound like a crazy person, but like, maybe there's some kind of energy that guided him, or like some kind of like spirit of the lake that has an energy that's dropping. To me, that lake is a very spiritual place. Like, I love that spot. Like, that's my favorite spot in Haddon Township, is that area. So, like, a little energy there. You can feel the trees on the side. Like, it's always been one of my favorite places to go. And maybe there's some kind of energy there that drew him there. Maybe something in my apartment that just, like, maybe there's something a bit more paranormal about this. Like, I don't want to say anything about that, because I don't want to sound fucking crazy, because I was sound like a lunatic if I'm saying shit like that. But...
How would a stranger know to leave Brendan in a place that is spiritual to this defendant? And I'm not criticizing him for that. That's so spiritual to him that he feels like a special kind of energy. A stranger's not going to know that. Brendan never lived anywhere. All you have to do is think about that picture of Brendan lying in the creek to know that he was carefully placed there. That he was lowered into the water. He was not thrown into the water. He was pulled up. That's how he got those little scratch marks on his chest. Probably pulled up a little bit to be sure that he would be found. Because he wanted him found. He didn't want him to be lost forever. A stranger wouldn't take the time to do that. A stranger would toss him in and run. You know, while we're on the subject of the stranger, this is why those cigarette butts don't matter, okay? It's why they're not important to this case. Because clearly, those cigarette butts belong to a stranger. A man was the best that they were able to tell us from the DNA. Everybody else that gave DNA samples was excluded from that profile, including the defendant's girlfriend, Sam, her boyfriend, Will, her parents, the defendant's family, and even the defendant's father's business partner gave a DNA sample. It wasn't any of those people. Those cigarettes were smoked by a person who has never been convicted of a crime at either the state or the federal level. We know that because of the CODIS testing. And they were far from Brendan's body. Remember, we had to make a special request to even get the state police lab to enter that profile into the CODIS system. So here's one. It was found right here, and to reference you, that's the vent pole. And the other one is right here where that orange flag is, which is clearly much closer to the side of Cooper River. If you killed a child and put their body in the creek, which we've already decided is impossible, but if you killed a child and put their body in that creek, do you take a smoke break on the way in with them? I mean, that's ridiculous. Or do you hang around and smoke too after you've got the body in the water? Those cigarette butts have nothing to do with this case. And in retrospect, based on their location, it seems most likely that they were from a person maybe out walking their dog or something like that. Brendan was simply not killed by a stranger.
Members of the jury, we've reached the point in our day when we normally have our lunch recess. So we're going to take a lunch recess. Again, don't discuss any aspect of the case among yourselves. And ask everybody to report back promptly at 1:30. We will be back in court at that time to hear the conclusion of the prosecutor's comments on charges. Again, discuss the case. Anyone who hears fellow jurors, I'll see everybody back at 1:30. Please be seated. Right back at 1:30.
Wherever you are. Yeah, but it's like points for
For purposes of media, after stations in my charge, we were then going to go to select the alternates. Again, the jury should not be photographed, and that process, the clerk by lot is going to pick a number. The two alternates are going to sit in those chairs right there. So while the alternates are being selected or when they come off, I ask you to keep the cameras off them, on the defendant, on me, on anything else, on Moran perhaps, but not on the jurors. All right? No problem. Thank you very much.
Gotta get ready. Head all here.
Okay, then you ready, Michelle?
Yes, sir.
Right, bring her around.
Yeah. Is it hot in here? It's never hot in here. Ever. I'm crying. I think I'm the only one. I'm not doing anything. I know when I'm. What's that? I know what to think. It's not as cold as it usually is right here.
It's gonna be cool, I guess. Prosecution does too, so.
What gets cold? Or hot?
Please rise.
Everyone, please be seated. Welcome back. Recall we broke the luncheon break. We were in the midst of Ms. Shaw's closing comments. I ask that she continue.
Thank you, Judge. When we broke off for lunch, we were just getting to the part where we had already covered 6 or 7 reasons why it's not reasonable to think or to believe that a stranger was the person who grabbed Brendan and killed him. We're about to move on to the next person on the list, which will be Julie, who's someone that you heard an awful lot of testimony about her. And I think it would be normal to consider her in all this because she just says so many hateful things about Brendan, excuse me, to the defendant, like really, really nasty, hateful stuff. But I think what the evidence has shown me is that she was up in New York City, where at the time she was a freshman at Pace University in her first semester. You saw her swipe times, you heard about her that Monday, that Tuesday, and that Wednesday. She's pretty consistent in the morning. Like most college students, she probably goes to grab a cup of coffee or something like that before she pops in the shower and heads off to class. The evidence that you heard was that she left Haddon Township very early on Monday morning. The defendant took her to the train station, drove her to the train station in his father's pickup truck in Trenton so that she could catch a New Jersey Transit train back to Penn Station in New York City. Saw video footage of her in the station and getting dropped off. Her cell phone from there was tracked from Trenton all the way to New York City, and that's where it stayed all day Monday, all night Monday night, and into Tuesday morning. Now, based on a lack of data, it seems clear that she turned her phone off on Monday night. But I don't think she did that for an illicit reason. She did it because the defendant blows her phone up. If you remember the calls and texts from that night in particular, and I am going to go through certain parts of the timeline momentarily, but the calls and texts from that night, he called her 9 times. He called her 3 times after she told him good night and that she was going to go to bed. And when she doesn't answer her phone, then he starts texting her, why aren't you answering? What are you doing? Who are you with? Julie had a math test Tuesday morning, and she told the defendant she wanted to get some sleep. She specifically told him that. And that was after a weekend. Well, I think it's reasonable to assume or to believe that she was tired and she did want to go to bed early, because remember, the testimony was they left his apartment in order for her to catch that train at 5:45 that morning. So they were up really early, and they were out the door by 5:45. And that was after a weekend of partying with the defendant and his friends. If you remember those 2 trash bags that were searched, There's 6 empty beer cans in the bag that has the pull-up diaper, and it's possibly that one's from Friday night. The other one is actually at the apartment. And the other bag contains 10 more empty beer cans, plus 3 empty beer bottles. So I'm sure that she was tired. But the big thing to consider is how on earth did she get here? If you remember her testimony when she was here in court, and if you remember some of the texts that you saw, when she was on her way down here, they were fighting about money because that was the day that his car broke down and he wasn't going to be able to come down from Trenton. And she's like, dude, I don't have the money to take 2 more trains. I have 1 more ride left on my subway pass. And, I need to know if you have any money. And he says, she makes him send her a picture of the money that he has in his pocket. And she said, show it to me, I want to see. In reality, what it would take would be, can we have lights, please? We know that her car is parked at her house in Pennsylvania. She does have a car, but she keeps it at home. I can't even imagine what it would cost to park a car in Manhattan. Full time. We know that she was broke, and it's about $50 round trip for her to take the train from her college to get here directly without getting a ride anywhere along the way, because it's actually 8 train rides if you consider it round trip. She's got a 20 or 30-minute subway ride she testified to from her campus to get to Penn Station. And from Penn Station, she takes that to Trenton on the New Jersey Transit train. Once she lands in Trenton, she then has to catch a SEPTA regional rail line into the city of Philadelphia. And then once she's in Philadelphia, she's got to get to Westmont on the Paco high-speed line. So up and back, that's going to be 8 train rides, and it's about $50. Once she actually gets here, she's then got a 10 or 15-minute walk to the defendant's apartment on Cooper Street. And that number comes from Joseph Ritchie, who was the guy with the suitcase going to school. He walks to the speed line every day. I think he said it was 10 or 15 minutes to make that walk in the mornings. She would have to do all of that in the middle of the night, alone, and without her cell phone. And then she's going to do what? She's going to use who knows what to break into the defendant's apartment, because his mother's testimony was clear. She locked the door and she checked the door before she left. Don't forget, she would have to break in sometime after 1:27 a.m. because the defendant was up and on his cell phone until at least that time. And if she arrived before the defendant was sleeping, he certainly would have heard her come in. And just remember, he stays awake because he's obsessing over her Snapchat account until that time. And then what's she going to do? She's going to take a few more minutes to quietly smother Brendan while he's sleeping on the couch all by herself then, and carry him, all 30-plus pounds of him. She's going to carry him by herself, because she doesn't have a car. She doesn't have a pickup truck sitting out front. So carry him by herself 3/4 of a mile through the dark woods and put him in his final resting place. That doesn't even seem possible, much less reasonable. And even the defendant says that she could not have done it. Lights, please.
She doesn't want anything to do with him or rather be around him. Like, she won't hang out with me if I have him, which is Julie Spencer. But she's in New York. She doesn't live down here. She would never do anything more or less. SP.
And I think that's something that probably the defendant hadn't thought about ahead of time, because he kind of blurts that out. He's like, her name is Penske, but she lives in New York and she would never do anything to him. I don't think that it ever occurred to him, by killing Brendan in the way and the time and the manner that it was done, that he was actually making Julie a potential suspect in the case. And that's why he goes to such great lengths to explain it, because he repeats that again in a later part of the interview.
But she wouldn't come down here. She wouldn't come down here. She wouldn't do anything, right? She just didn't like the situation. She would leave me if she felt like it was something that was...
What do you think there's something on her?
Because I don't see him just walking out the door and just leaving and going all the way down the Cooper. That sounds so unlikely to me. The fact that he ended up down the Cooper is blowing my mind. Like, I don't understand. For one, I don't...
We already heard the rest of that clip. And that's the fact that it would be nearly impossible for her to do that, and the defendant doesn't think that she did it. That's not even the most important piece of evidence in this part of the case. The most important thing that you need to keep in mind is the is the twisted and one-sided nature of their relationship. She is not obsessed with him, not even a little bit. He is obsessed with her. He is constantly preoccupied with thoughts, what she is doing, and who she might be with. She has rejected him and broken up with him numerous times. And he begs her and he pleads with her to please take him back. There was a list of reasons in the text that she sent that you all saw when we were reading them back and forth. Of the reasons why she didn't, and this is in October 6th. I deserve better than to only spend every other weekend with my boyfriend, and I've been doing a lot of thinking last night. We ought to end this. Let's face it, you have your life in New Jersey, and I have mine in PA in New York. We don't have money to really do anything fun or go out anywhere or buy anything except cheap stuff, and we now barely have time because I'm going to be seeing you I don't know when. This is ridiculous, and I can't believe I thought it would turn into anything legit. She doesn't want to see him anymore. She wants to move on with her life. She's in college and her life is changing. His, on the other hand, is not. And don't forget, in addition to all those complaints that she had about him, her parents don't like him. There was texting about that. There's a 17-year-old girl who's away at a university in a major city, and she's going out with some 22-year-old dude that has a 3-year-old. This is what her parents thought, and this is something she communicated to him. They believe that having kids out of wedlock and before you're financially stable is very stupid, immature, irresponsible, and very low class. I agree with them on that 100%. They also believe that education is incredibly important, and those people that are able to get a higher education should. If they don't, then they clearly don't want to be educated, and therefore don't want to enrich their lives. Blah, blah, blah. She goes on and on and on about all the reasons why her parents don't approve of him. Julia Stensky was not desperate to stay with him. He was desperate to stay with her. Think about some of the things that you saw on texts. He cries about her when he's at work. He cries. I'm up on the ladder right now. I don't know what I'm going to do. There was one text where he said he got physically ill at the thought of her leaving him. It is pathetic. She's 17 years old. He's grown up. But if anything, it's just so clear that all of that craziness is so one-sided. To refer to that texting as immature or anything else is really just too simple. Because he's so consumed with thoughts of her, he's so jealous, he's so paranoid. Those texts are disturbing. They're not immature. She's nasty. She's a nasty girl, there's no question. But she's not the one with the problem. He is. If you go back to their relationship, I think the testimony was that they met on a dating app in the middle of June of 2015. They had a fun summer, and then she went away to school in the beginning of September. And then she wrote that nasty blog post on September 1st. Do you remember that? It was called Where We Stand Now. Detective Rhodes read this entire thing into the record. But basically her position, and this was right when she went to school, she said, I am my own person with my own responsibilities and goals. My only real responsibility right now is to get an education and secure a well-paying job. That's it. If anything is tying me down, that's it. Which is why I will definitely be in New York until 2019 when I graduate with my bachelor's. That's it. Then I can and will go wherever my life takes me. But you're tied down to New Jersey forever. You'll never be able to leave. Your entire life is at fucking stake, and it's all because of your mistake, meaning your kid. Yes, I view the kid as a mistake, and you told me he wasn't planned, so I will never view him as anything different. He might be a great kid and might turn out to be a great human being, whatever, but he's still a mistake. Your mistake as well as your ex's. And because of him, you two are tied to each other because you both insist on being in that kid's life at the exact same amount. Here's the problem. If I stay with you, then I tie myself down to you and your mistake, meaning it becomes my mistake too. Now, it's not my kid and it never will be, and I'll remind you of that every day that we're together. But if I'm tied down to you and you're tied down to him, I become tied down to him too. True. Yeah. When she posted that blog, at that time, the defendant's response to it was to say, as Mr. Hoshino pointed out, that he loves him, that he would always be in his life. He would be in his life no matter what, and that Brendan was not a mistake. The reason that you know about all those texts is because we showed them to you. The state showed you those texts. Because it's not necessarily a question of what he said that night. It's a question of when he said it. The reason we spent 3 hours reading texts back and forth to you during the trial is so that you can understand how and when the change in their relationship occurred. There's no question that the defendant changed over time. And the change was drastic and really happened over the course of just a few weeks, because everything's fine until September 1st when she goes away to school. But by October 6th, he's promising to do whatever it is that he needs to do in order to keep her. And if you recall all those texts from October 6th, those were the ones that we started to read after lunch. And I believe it was more than an hour, and I believe there were more than 800 texts that day. And I'm not going to go through them all again, but we are going to look at a few. We begin on, can I have lights, please, Deb? Thanks. Friday, October 2nd. He says, and remember the green texts are his. He says, hello, and she doesn't answer. And he says, that's when I think you're with someone. You don't text me. October 3rd. He goes to this website. This was on his phone. Luce and Quanto testified about this. He goes to read Julie's funny stuff on her Tumblr account, and he reads what I just read to you, the Where We Stand mail blog. That's what he was in. Sunday, October 4th. They're breaking up again. He says, we're obviously not breaking up like that. Just come talk to me, please. She says, no worries. I'm on my way to the Patco station now. Take care, dude. He says, please come back. I love you. This is stupid. October 5th. The next day, Monday. It's always a troubled day when Julie goes back to school. She must be back at school, because this is what he says to her. Why did you hang up on me? I did nothing. She doesn't answer. There's a reason you hung up on me. Someone came into the room or something. She doesn't answer. Seriously, WTF? She doesn't answer. Really, that's sketchy. She doesn't answer. Hello? She doesn't answer. Then finally she says, what do you want? And he says, why are you doing this? Who came to your dorm? No answer. Question mark, question mark. Again, hello? Tell me who's got a problem. It's not her. Tuesday, October 6th. This was the date when there were so many text messages that went back and forth. My life is with you. I love you and I want this to work. It's just rough right now. It will get better. This relationship is worth fighting for. What relationship? Like this is like a summer thing here. And Julie says, so keep on living in New Jersey and talking to your ex and having your kid every other weekend and scrounging around for $5 just to eat. I don't want a boyfriend. Same day, says the defendant, I don't want to go a month without seeing you. I can't. You're too important to me. You're all I think about. Same day, please see me, sad face. Please, I love you. I don't want it to be like this. I'm willing to do anything or change anything for you. You really don't know how much I love you and how much this is hurting right now. Again, I'm willing to do anything for you. I would do anything for you. And Julie says, okay, well then I want you to not have a kid in your life. Do I get that or no? And he says, you can always get what you want in the future, not the past. And I don't claim that to be some sort of confession. Of course not. But it just goes to show you, and the relevance of it is, the change in his mindset over the course of time. And this is when it really starts getting bad. She says, okay, so when will he be out of your life? How long do I have to wait? 15 years? More? Less? Still on the 6th. I get really upset when I think about never seeing you again. I don't want that to happen. I love you. I'm really scared and I can't stop thinking about it. Over and over and over again. She says, you won't change this. I know you won't, so don't bother telling me you'll do anything for me or whatever, because you won't. So don't say something that isn't true. And then he says, well, I don't have a choice. If I don't have him every other weekend, I have to go to court and have child support, and I can't afford that. Still on Tuesday, I do want to move far away from here. I want to get a lawyer and see what my options are eventually. I've been thinking about it. So how do we go from September 1st, he'll always be in my life, I love him, to, well, you know what, maybe I'll call a lawyer and see what my options are. And on that same day, again, October the 6th, this is what he was looking at on the internet. How to study abroad for free. Where you can study abroad for free. Top universities. His priorities have clearly changed. Wednesday, October the 7th, and we're still fighting. And I'm scared because I feel like I'm losing you. And I don't want that to happen because I love you. Same day. I get really upset when I think about never seeing you again. I don't want that to happen. I love you. I'm so scared. I can't stop thinking about it. And she says, well, there's nothing I can do. Do you want to never see me again, he asks. She says, sure. And then he says, is there any kind of hope I can get from you? Thursday, October 9th. Now keep in mind, she usually comes down on Fridays. She'll come down on a Friday night, we'll pick her up. She stays Saturday, Sunday, and he takes her home early Monday morning, or takes her to Trenton early on Monday morning. So this is Thursday. And she says, and I'm still here. Does that not mean I love you? And he says, I know you do, but you're making me feel so unwanted and so unloved, like you just don't give a shit about me anymore. I love you, Julie. She says, you're not unwanted and unloved, I promise you that, and I'm sorry if that's how you feel. I don't mean to make you feel like that. He says, I love you. She says, I love you too, DJ. I don't even know how to put in words how much you mean to me. She says, I don't need you to. I always prefer action to words anyway. Friday, October 9th. Now she's supposed to be coming down. This is the day he's out working with his dad and wants to leave the job site early. His car has died and he needs to get Julie from the train station in Trenton. And if you recall, when you saw it in the complete context, she was really riding him like, well, if you can't get here and get me, then I'm just going to go back to my dorm because I only have one subway ride left and I'm not sitting in that station for 3 hours, blah, 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 blah. Because that's how she is. And his response to all of that is, can we please not end this? I really don't want it to end like this. I'm actually crying while I'm on the job site. I don't know what to do. All of these with no response. So you're really just coming to end it with me? She doesn't answer. Question mark, question mark. If that's really the case, don't bother. No answer. I just want to fucking die. No answer. Crawl in a hole and die. No answer. Hello? Question mark. Still no answer. So you're really just coming to end it with me? Question mark. No answer. Hello? Question mark again. Again. She's not the one with the problem. So that weekend, October 9th to 11th, because somehow miraculously she does make it here, finds her way here on all of those trains. Excuse me. She arrives via Patco Friday night. He picks her up at the train station. That came from all the texts that you heard. The fact that he picked her up there. So what do they do on Friday night? If you remember what he told the police during his statement, they had a really big fight about whether or not to maintain whether or not they were going to keep this relationship going. And keep in mind, Friday night is the only night out of this whole big weekend that Brendan was supposed to be with his father. Friday night is the only night that he has Brendan. And what's he doing? Holed up in the bedroom having a big fight with his girlfriend. Lord knows where Brendan was at that time. Probably sitting in the other room because that's what they usually do with him when he's over there. Remember that text? Saturday. On Saturday morning, they all wake up, and the defendant and Julie spend the day, according to her, sitting in his apartment. They just sit in his apartment because, as she has complained about repeatedly, they have no money, there's nothing to do, you just can't do anything, you don't have any money. But at this point, Brendan, fortunately, is out at the zoo with his grandmother, and he spends the day with her. Saturday night. Saturday night is the night that there was a party because Kevin Keyes and his girlfriend Amanda Forsland were in town that weekend to visit all of their friends. And Brendan spends that night at his grandmother's house. He spends the night there in his dad's side of the family house. So Sunday, we get to Sunday. What does the defendant and his girlfriend do? They sit in his apartment all day. Because again, they don't have any money, they don't have a car, they can't go anywhere. But if you recall, towards the end of the day, they did take a walk to Cooper River. And that was where, it was at that time, I want to say it was at 6:32, I think it's coming up. That was when they took that picture of the water or the bird or whatever it was. And I want to address something real quickly while we're talking about that photograph that he took, because That brings us back to the testimony of Luz and Quano. The defense attorney, in his closing, made some pretty disparaging remarks about Detective Mike Rhodes. The only reason that Detective Rhodes was asked about not providing the full file pictures to the people at Cornerstone, to Luz and Quano, was because the defense attorney raised it with Lou. He said, you know, we didn't really get the whole phone. They removed a whole bunch of files. We had to remove the files. We can't hand over to someone else pictures of a naked person who's under the age of 18. It's illegal not how to do that. That is why they were removed. And Mr. Ficino knew that. We told him. We didn't give it to him either. We didn't give it to anybody. You're the defense attorney. You may come in and inspect it so that you can see what we've done, but we can't distribute stuff like that. That's why it was done. And it was brought up to explain to you why the file was really arguably altered before we gave it to our expert. And if you remember the testimony from Detective Rhodes, you can't just select photos out, not from a Cellbrite extraction. We used to call it dump. I'm trying to call it an extraction. But you can't just pluck photos out of there. You either get the file photos or you don't. And we took them out. And that's why that was done. And those accusations against Detective Rhodes were made, in my mind, a little more offensive by the fact that the person who first raised the idea of the defendant having naked pictures of Julie was the defense. Because if you remember, they were talking on, there was some texting that went on, I think Monday night, and the defendant wanted to snack with her. Not snack, I get all these mixed up. Skype. He wanted to Skype with her, which is the live video chat, and she didn't want to do it because Brendan was going to be there. And the implication was that she didn't even want to talk to him if his son was there. They're the ones that said people strip on Skype. I almost fell out of my chair. I never heard of that. So it's really not to disparage anyone. It's just to explain the evidence and what it might mean. Okay? Just want to clear that up for Detective Rhodes. So Sunday, we know that Sunday evening, I guess, they're down at Cooper River. He takes that photograph of the bird in the water. And then they go back to his apartment, and the testimony was that Kevin Case and the enforcement came over. They watched some Netflix, drank some beers, and everybody left early because the defendant had to get his girlfriend up early in the morning so that he could get her to the train station right now so she could make it back to New York City. And here's the photograph that was taken. This is a location where they took that photograph. It was at 6:32 on Sunday evening. And by now, I'm sure that you all have that map memorized. And you know exactly where that location is in Haddon Township. Almost exactly right where Brendan was. That brings us to Monday morning. So we know they're going to get up early. We know she's going to go to the train station. I believe the testimony was from her. It's either a 6:47 or a 6:48 express train. She gets on that. So it's been about 40 minutes, and he starts texting her. She's still on the train. She's probably not even in New York City yet. He says, hi. She doesn't answer. A couple minutes later, I miss you, come back, with a sad face. A couple minutes later, it's about a half hour later. She still hasn't answered him all this time. What classes do you have today? Finally, she answers, and she says, economics, civil war, and politics. I said, politics? Yeah, politics. And he's like, great. Then he has to add in, I just want to hold you with the sad face. She's been gone for about an hour and 15 minutes. And cuddle. What are you doing right now? She has answered none of this. She's making her way back to her dorm room still, is what she's doing right now. When she doesn't give him a quick enough answer, she gets the question mark, why aren't you answering me? And she says, I got back to my dorm room, I unpacked, and now I'm heading to class. Because that's what I do. I'm a college student. I have places to go, things I need to take care of. I just got back to school, and I need to get into class. You know, you should just sit somewhere else today, is what he says to her. She's like, what are you talking about? Is her response to him. And he says, in class. Again, she says, what are you talking about? And his reply is, like not in you and Gio's little corner. Well, where did that come from? It came from up here in his head, because that's what he's thinking about all the time. She's been out of his sight for, what? Not even 3 hours. And he's all over her about Gio already. And she says, but I like to sit next to Ashley and Bailey, and we all sit in the same corner. Oh, sad face. He says, his response to that is, I hate this so much. You know what I thought when I saw that? Not as bad as she does, pal, okay? Because she's up there trying to go to school and do what she's supposed to be doing. Like, lay off. 3 hours later. What are you doing? It's 12:42 now. It's a little bit before 1. Oh, no answer. It's got 2 question marks. Again, no answer. 2 more question marks. And I mean, even if we just go back and look at that really quickly. So from 12:42, he wants to know why she hasn't answered him by 12:43. And then by 12:47, he again wants to know why she hasn't answered him. Then he calls her. 41 seconds. That should be a clue by now. Anytime it's 39 to 41 seconds, it goes to voicemail, because we all know she doesn't answer this call. And when she doesn't answer the call, he texts her again and says, hello. And you know why he's doing this? Because he knows what her class schedule is. And he wants to know where she is. Because she shouldn't be in class right now. She's not in class right now, as you'll see when she does finally answer him. Why aren't you answering? She says, I was talking to my economics professor. That's why I wasn't answering. And he says, and then she follows that up with, I'll call you when I'm back at my dorm. He's like, well, your class ends at 12:05 though. And it's obviously it's 1:04. So who are you to be speaking to one of your professors for an hour? Right? If you're not in class, I expect you to answer your phone. Not in a pushy kind of way, in a desperate, twisted kind of way. Later that same afternoon, after that exchange, if you recall, there were a whole bunch of texts earlier where they were talking about what they were going to do in the upcoming weekend, and I can't remember which one of them suggested, but one of them did they would do some baking or something like that. And she texts him and says, so you need some all-purpose flour, correct? This text takes place over a lengthier amount of time. He says, yeah, why? And she's like, well, because I'm doing shopping. He says, when? He says, you don't need to get the flour. It's okay, I'll get stuff. She says, I already got it. Did you go by yourself? Yes. Yes, she did. He says, you're the best girlfriend ever. So around 5 o'clock now in the evening, he's wrapping up his work day. He's getting ready to go pick Brendan up from Sam, because that's where Brendan's been. We hop in here, it's 5:05 on that. This is, there was a couple of texts back and forth earlier where they were just kind of talking, what are you doing, blah, blah, blah. So this is where he says, what are your plans to her? She says, I'm going to study for my test tomorrow, then I'm going to go to sleep. I'm going to bed around 9 p.m. because I'm really tired. This is at 5:20. How's that a response? I'm going to go to bed because I'm tired and I have a test tomorrow. Okay, did he talk to you today? And she's like, who? Gio. Who else? Who else does this man ever think about except Gio? At 6 o'clock, it's now an hour later. How's class going? He sends that to her because he knows that she's actually sitting in class. And then he corrects going. She says, boring AF. And as soon as he gets that, this seems like a good time to hop into her Facebook account. I took out all those extra text or extra slides. If you recall, when this was presented with Mr. Sanquanto, whenever you log into Facebook, there's a series of about 6 or 7 things that has to happen. You go in, you see the welcome screen, you sign in, then you can either check messages or check whatever. In this, for this presentation, I hopped right into the messages. So 603, he's looking at Facebook messages from Giovanni Borgia. Gio. And the testimony, as I recall, was that this message was actually posted by Gio on October the 9th, so it's been there for a little while. And then while he's at it, he goes in to check her friend Celeste McDonald, and he goes to check her friend Monica Ross to see if they've Facebooked her, okay? And then he logs out at about 6:04. So at this time, now it's around 6 o'clock, Brendan is with the defendant. He's been picked up from his mom's house, dropped off, so they're together at the apartment. And at some point, the defendant's sister sends him those texts and asks him if she can give him a bath. She wants to know if he can come over to their house. There's no tub in the defendant's house, as you saw. The bathroom in that apartment's very tiny. And he's like, well, yeah, sure, but you have to pick him up, and you have to bring him back. And she does. So now, he has time to get back into Facebook and see what's going on with Julie's accounts. Okay. And then he calls her. This is where the 9 or 10 phone calls start. It's 8 o'clock at night. Brendan's still over at his grandparents' house getting a tubby with him, getting his pajamas on, getting ready to come home. This guy's blowing Julie's phone up. He calls her at 8:01. 8:01 again, 8:03, 8:03 again. They're like 50 seconds apart. 8:05, 8:06. And at 8:06, after he calls her all those times and she doesn't answer, she sends him a text and says, I'll call soon. Okay, like I can't talk right now. Stop blowing that phone up. He gets that text. What does he do? Calls her. And then, not even a minute later, what's she doing? She just told him she'd call him in a minute, right? What you doing? And then finally she calls him back. And it's not even 10 minutes later. It doesn't even take her 10 minutes to call him back. They speak on the phone for 4 minutes and 7 seconds. According to what he said in his statement to the police, they talk, they say goodnight, she's going to take her test, she wants to go to bed early, whatever. As soon as they hang up, good night, cutest person ever. Like, dude, I just got off the phone with you. And she says, good night. I miss you so much, I can't wait for this weekend. And these are like rapid fire texts if you look at the timeline up top. She says IKR, which I believe means I know, right? Sends her a string of hearts, 12 of them, I counted them. This is an example of when the texts come in backwards, because what she actually says is, good night, love you, except she spelled it wrong, so then she corrected it with a U. Sweet dreams, he says. She says, thanks, it's now 8:30. Now at this time, right around 8:30, the testimony was, this is when Lisa Creato and Sarah Creato are bringing Brendan back to his apartment. He's getting a piggyback on his Aunt Sarah. He's freshly bathed, got his clean pajamas on, and his grandmother's carrying everything he needs for school the next day. This is right around the time when they arrived. So that should have been it, right? He talked to her, he texted her, she texted him back, and it was all about the night, and it was all about sweet dreams. That should be it, but it wasn't. 8:57. Remember, the testimony was that, both in his statement and also from Mrs. Creato, that Julie and Lisa Creato hung out at the apartment for about 20 minutes. The defendant is actually, oddly, very specific in his statement when he talks to the police. He says, he came at 8:30, they left my house at 8:50. It was about 20 minutes while he was hanging out with his mom and his sister. I'm sure they were both continuing to visit with Brendan. So 7 minutes after his mother and his sister are out the door, despite the fact that he claims that he read 3 Dr. Seuss books to him, he's back on his phone at 8:57. And where is he? Getting back into Facebook again. And then he decides that he wants to send this to Julie. And this is interesting because, and again, I cut a lot of these out because you've seen it, and it's so much, it's so many, and so it's just an overwhelming volume. He says, and beautiful. Here's why he says that, and here's what he was doing. If you remember earlier when she told him that she was a good girl and went to the store by herself, and he said, you're the best girlfriend ever, she said to him, why? Why do you say that? And he gave her a couple of answers and then moved on. The reason he starts doing this again is because he's obviously sitting in his house going through the old texts now that she's in bed, right? And oh yeah, why are you the best girlfriend ever? Let me add some answers to that. Because, and that's why you see here, and beautiful, because that makes no sense other than that context. And you're amazing. It's 9:02. You're amazing. She's amazing. You have pretty eyes and an amazing smile, pretty hair, and a cute butt. Smiley face. He's not getting answers, so he's back into Facebook. Because she's not answering him. Because she's sleeping. She didn't have to tomorrow. She's been out partying all the weekend. She's tired. She's a college student. That's all they do. Hopefully they study. Definitely they sleep. Oh, and also at 9:47, you're super sexy. Just can't let it go. I mean, this has been going on for over an hour now. He's sending her these texts that she's not even answering. So what does he try to do? He tries to call her. Why not? She didn't answer. You know what? Why not call her again? That's a good idea. This is at 9:55, and he can't get a hold of her, and he can't stand it. So what he does is, he gets in his Snapchat account, and he sends a message from him to her. And you know what? While he's in Snapchat, while he's already in there, let me just change accounts. Let me see what's going on in Julie's Snapchat account. And that is what he sees at 10:02 p.m. Julie got a snap from Gio, and he saw it. The reason that you don't see the content in messages like this is because a snap is designed to disappear when you open it. The testimony was, the person who sends you that snap can set a duration for the message, 5 seconds, 10 seconds. Once you see that, it disappears. It can't be seen anymore. Mostly it's so parents can't search their kids' cell phones, but that's the way that it works. And that was at 10:02 p.m. After that, he calls her. He actually waited 5 minutes before he called her after he saw that snap, which is interesting because this guy doesn't wait 5 seconds to call you. He must have really been chewing on whatever was in that Snapchat message, really thinking about it, thinking about what he was going to say to her. But he called her at 10:07. She doesn't answer. Do you think he rolled over and went to bed after that? Just snuggled on down in his covers and went to sleep? After all that, after seeing that message, the evidence from the forensic expert on the cell phone was that he was up until 1:27 a.m. in her Snapchat. And then he was watching him, and he was waiting. Because remember, those snap messages disappear once they're viewed. That's the whole point of Snapchat. And this defendant surely did not want to miss another snap, or it's called snap, from Gio. And that's why he was on her phone like he was. Do you remember how many hits there were on it? It kept showing up like it was a story. The testimony was that you have to access it for the story to show up. That was clear. I know that Mr. Ficino tried to make some hay out of the fact that I think it says Snapchat instant message. That it says that on everything. There's stories and there's snaps. Wilson Quanto testified quite clearly that you have to access a story in order for it to make that kind of an imprint on the timeline of your cell phone. If you have any questions about that, I would strongly urge you to ask for a readback of his testimony. He is an expert. I don't care if he's only done 3 Snapchat cases. He explained to you that the platform for almost every application is identical. They're not that complicated. They tested it, they looked at it, and that is how it works. There is no way the defendant saw a message, Tried to call her, she didn't answer, and went to bed. He was in that account all night. So Tuesday, October 13th. This is the day I find her. I want to talk to you about, can we have lights, please? Yes. I want to talk to you about the defendant's behavior once Brendan was missing, okay? I want to start out by talking about the 911 call. You've heard the 911 call twice now. And yes, I am going to argue to you that his affect and his tone are, to say the least, odd. You don't really hear any distress there. He's not particularly animated when he's talking to the 911 operator. You know, everyone who has a child, who has ever had a child, has probably lost that child at some point. You know, kids will wander off on the beach when you look away for 2 seconds, or you lose sight of them on a crowded playground, or they wander off in a store, or something like that. It's a very, very bad feeling when you don't know where your child is. And for the first few minutes, a reasonable person, they might be able to say to themselves, okay, let me calm down, let me focus here, let me really look. Let me really look at this little crowd of kids to see if my child is there. Let me look. But he should have been well past that moment of composure by the time he actually called 911, because according to his story, he woke up and Brendan was gone. He just wasn't in the house anymore. He checked the apartment. He then went outside. He looked up and down Cooper Street. He went to the corner. He looked up and down Virginia Avenue, which is the street that his parents lived on. And then, at 6:02, he called his mother. At 6:03, he called Sam. And it wasn't until 4 minutes even after all that he called 911. He should be in full panic mode by then, but he's not. He's not even close. And that's a little odd for a guy who constantly complains in his text that he's having anxiety. How many texts did you see from him? He said, I'm having anxiety. Remember some of his texts? The guy who cries like a baby at work because he thinks Julie's just coming into town to dump him? Or the guy who gets physically ill at the thought of losing her? But he can certainly hold it together well when his son is missing, as you can tell by the 911 call. And the reason for that is because, to the defendant, Brendan is not actually missing. He knows where he is. He knows that Brendan is dead, and he knows that he's in that creek, just waiting to be found. And that's why he's able to check Julie's Snapchat account at 6:40 a.m., while all the searchers are gathering, and all the cart team is assembling, and the big truck's coming in that's going to be the command center. The fact that he checked her Snapchat account in the middle of all of that is a game changer as far as understanding him, as far as understanding what actually happened in this case. No one in their right mind would do that. If Brendan was really missing, and if he thought Brendan might be alive somewhere, he would not be his girlfriend's Snapchat. I want to take a look at what the defendant does when he first arrives at Cash Police Department. Okay. This is when he's going to come in with Sergeant Saunders. Quick lights, please. There's Sergeant Saunders.
Sir, you want water? That's why I keep you want something. Okay. Did you meet the second cleaning? I think you've got your lights, right? And then another guy's coming, and then we'll sit down on the floor.
Have you ever heard of the expression, I've heard it referred to as cell phone anxiety? It's the need to constantly check your phone because you think you're missing something, whether it's an email, a text, or whatever. You see it everywhere you look today. Anytime you're standing still, everybody's on their phone. Whether you're standing in line at the grocery store, you're sitting at a red light, anything you might be doing, most of the people are standing there looking at their phones. Not this guy. He's going to sit here for 1 minute and 30 seconds, and his phone is in his pocket. He never checks it, which is really odd, not just because he's constantly on his phone, but because his son is supposedly missing. And there's a Facebook group chat that was started by one of his friends that has all of his friends in the neighborhood supposed to be out checking the area for Brendan. You think he might be interested in what's going on. He might just reach in his pocket and pull out his cell phone to see if there's any updates on his son. But he's not interested, and he doesn't do that. And again, the reason is because he knows they're not going to find Brendan. You know, at the end of that clip, Sergeant Saunders took the defendant's iPhone 6, and the defendant did later consent to a search of it. But there's a reason that he did that, I suggest to you. He wanted the police to see his phone, because he knew his phone never left his apartment. That's easy. All you have to do is leave your phone at your apartment when you move Brendan's body. There's nothing to that. It's the one thing he thought of to do. And he actually discussed that when he was talking to Sam on the consensual recording. He said, I know they can check the GPS towers and show my phone didn't leave the side of my bed that night. He knows that.
I know they can check the GPS tower and show my phone didn't leave the side of my bed that night.
That's why he consented to the search of his phone. Now, if you recall, at the same time when Sergeant Saunders was taking his phone, he asked Sergeant Saunders if he could use the restroom, and he was taken to the restroom. So this part is after he comes back from the restroom. Whoops. Once Sergeant Saunders took his phone, he used the restroom and came back to the only interview room at the Haddon Township Police Department. He sits like this for a very long time. And you sat through the whole thing when we showed the initial clip, okay? You may have noticed it when you watched it the first time, you may not have, but he yawns a couple times during this time period. On the largest and most generous spectrum possible human behaviors, this does not comport with the notion that your child is missing. I think in Mr. Ficino's closing, he said something about the defendant kept asking him, where is he? Is there anything going on? No, he doesn't. He never did that. He didn't do it until Mike Rhodes walked in to tell him that he found his son deceased. That is not a man who's waiting to hear about his child. He's not waiting for them to find his son. He's waiting for them to find his son's body. That's what he's waiting for. And as you all know, of course, we did find Brenda. I want you to take a look at how the defendant reacts when Detective Mike Rhodes arrives to notify him that Brendan has been found. And you know, when making the notification in this case, Detective Rhodes hesitated for a few seconds after telling him that Brendan had been found. I believe his actual words were, "We found your son." He didn't do it on purpose. He didn't do it to set him up. He wasn't trying to make him look bad. The reason he hesitated is because it's just a really hard thing to do. Making homicide notifications to family members is one of the hardest things a homicide detective has to do. It's very difficult. It's hard to tell a stranger that their spouse or their child is never coming home again. So Mike Rhodes says, "We found your son," and then he hesitated. It's for about 3 seconds. I'm going to play it in just a minute. And the defendant did nothing during that little gap there. He didn't say anything. He didn't ask anything. When the detective said to him, "We found your son," what's the natural response to that? Where is he? Is he okay? Is he hurt? Can I see him? Nothing. He just sits there and waits for it because he knows that it's coming.
Yeah, I think he said, tell you real quick. love her so much. What happened? What happened? That's what we're trying to find out right now, okay? Where was he? He was found on the shoreline. The shoreline of what? Oh, God. Where did he get out? What's that? Did he do all that? We don't know that this time. That's what we're trying to find out. Oh, my God. I'm so sorry. What did I do? What did I do? Here's my wife. I'm sorry. I'm so sorry. No! I was just out there. We don't know that. There are a lot of questions that we need answers to. We need your help to find out. Okay? And this is very difficult for you right now. Alright? Well, we need to find out what happened last night as far as, how the night progressed. Okay? Okay. Alright? You need a moment? You need some water in there? What are you doing? Okay? I'm trying to breathe. I know, this is hard. This is hard. It's very hard. Last night, why people want to
The time at the bottom down there is 10:19 and 15 seconds. He starts talking 1 minute and 35 seconds after he is notified of his son's death. The detective doesn't even ask him any questions. He takes a big breath and starts spewing this story that includes a lot of details. And I want you to watch this part where he tells his story.
My sister texted me asking me if she can give him a bath. They just got to the tub, recently refinished. My sister was getting it herself. And I said, yeah, that's fine. I brought him over there. They gave him a bath. And then they brought him back to my house. I said to him, what time are you bringing him back? They said 8:30. Okay. I said, okay, around 8:30, I want to go to their house. Okay, I said, my dad was there. I said, no, they left. So I called my mom, she said she was at my house. I said, okay. I went back to my house, they lived with Clemson. She went upstairs. And my sister stayed with me for 20 minutes. Until about 8:50. And we were just sitting there talking, and then they left. I read his bedtime stories. And we read 3 books before I let him go down to bed. I read him, the first book was Rebutting, and the other places she'll go, and then it was the Lorax. And I said, it's time to go to bed. And he put his bedroom, I didn't know, I gave him a pillow, he said, no, I don't want it. And I took his pillow, and I put it on the side. So I gave him the blanket, laid it down, I heard him battling against the room like he normally does before he goes to bed. And in the morning, I go to my room, I'm trying to talk to my girlfriend, she goes to bed, and I'm still trying to communicate with her, trying to call her and all this, and I didn't get a hold of her anymore. She went to bed. She lives in New York. She goes to there. So I went to bed. I wake up 6 o'clock in the morning, and I just go to check on him. He's not there. And I start freaking out, looking around for him, and I call the cops. That's all the information I have right now. I'm going to back up real quick. Yes, you see.
During that entire time, the only thing Detective Rhodes said was okay. 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 Because he's just giving all this ridiculous information. I always read him 2 stories before. I read in the Lorax, I read in Other Places You'll Go, and we read the Yertle Turtle. It's less than 3 minutes into it before he starts talking about Julie. About trying to get in touch with her because he was worried about her. So now we're going to have a few more questions here.
You're selling one at your sister's house. Where's she? On Virginia Avenue, right down the street from me. What's the address? 22 Virginia Avenue. What's her name? Sarah Creato. Sarah Creato? Yes, she is like a mother to my mama. He's with her a lot. She's like my main babysitter. She's, who stays at Sarah's house? My parents. Your parents? What's their names? Lisa and David. Okay. How often does your...
This is less than 4 minutes after he was told to bring him Sam deceased. How's that possible?
She's not going to your sister's house. Those are pretty regular. Like, not regular. I have them.
I have them Monday through Wednesday, and every other weekend. And I leave him if I visit. My mom watches them for me a lot when I go out with my friends.
Okay.
Or that kind of stuff. She's looking at her pretty often.
Okay. Now, who do you live with besides you and your son? Is anyone else?
No, it's just me and him. Okay. My girlfriend comes and stays with me a few days on the weekends.
Okay. What about her name's Laura? What's her name?
Samantha.
Where does she stay?
She stays with her parents on Merrick Avenue.
On Merrick Avenue?
Yes.
Okay. What is that? How close is that in relation to your house?
It's a couple. That's maybe a mile.
Maybe a mile? It's in that township?
Yes.
And how long have you been living there?
And it goes on from there, in that same tone and in that same manner. This exchange occurs 9 minutes after he was notified that Brendan was found in the creek.
Okay, what time do you finish something?
9:30.
9:30.
The stories are on like 8:50, almost 9 o'clock, I would say. I read his 3 stories.
Okay.
And then I moved to bed.
Okay, after you put in the bed.
Sorry, I'm going to pause that for a minute. This part, there's a couple of clips I'm going to ask you to look at that are just lies that he tells to the police that I want to point out again. But I want to go back to the way he reacted to being told that his son had been bagged in. I want you to think about that reaction and contrast his reaction of the news of Brendan's death with what you saw from the Derby K-9 officer, Constance Nicholson, when she was here in court. She showed more emotion about Brendan's death more than a year and a half after she saw him in the water than his own father did when he supposedly found out that his son was going to be gone forever. Or how about crime scene investigation detective John Ellis, who lifted Brendan out of the water and then held him on his lap all the way to the medical examiner's investigator's car. Detective Ellis was in tears when I changed gears in the questions that I was asking him because he knew what we were going to have to talk about. And it still, to this day, makes him cry. That guy doesn't cry for 5 minutes. A homicide investigation into the death of a baby or of a child takes a tremendous personal toll on every single person who's involved in it. So wouldn't you expect it to affect a child's father at least as much? At least as much, if not more. There are no rules for grieving, and people do grieve in different ways. No question about that. Not like that. Not like that. That was not grieving. That was not the behavior of an innocent man. So I'm going to look at a couple of things that he said to the police that are just not true. Back that up.
Okay, what time do you finish something?
9:30.
9:30.
The stories are on like 8:50, almost 9 o'clock, I would say. I read his 3 stories.
Okay.
And then I moved to bed.
Okay, after you put in the bed, what do you do next?
I went to my bedroom. I had the laptop open. There was some video. I decided not to watch it. I just closed it, put it down, and tried to talk to my girlfriend, and then I decided to go to bed.
What time did you talk to your girlfriend?
I'm trying to remember that exactly. My girlfriend, I was talking to her probably around 8:30. We were just like texting, saying good night and stuff. She said she was going to bed early. She had a math test in the morning. I thought it was weird she was going to bed at like 8:30 though.
Okay.
And then I kept trying to get a hold of her later that night because I just talked to her because I was just getting nervous as she was like talking to this other guy down at school. So I just kept trying to call her over and over again just to get a hold of her.
Okay.
And I was
In that previous clip, basically what he's talking about is he read all those stories to his son. He did not read those stories to his son. His mother and sister left at 8:50, and he's back at her, I think it was her Facebook account, at 8:57. He was on his phone all night. He was not reading to his son. He's also going to tell the police in the
And then on the bed after that, I was calling her, trying to call her.
She tried to call her 9 times.
I was being jealous because she went to bed and she was walking this guy at school and I was jealous and I thought it was weird that she was going to bed early so I could try to call her and then also I made her Snapchat on there.
So you're jealous of another guy?
Yeah, she was talking to you. She said she's still friends with class, and I was just being jealous and I kept calling her. That was my reason for that.
Okay.
He did not go to bed after he tried calling her, and you know from seeing his cell phone examination, he was actually on his phone for another 3.5 hours, monitoring her Snapchat account, waiting to see if something else came from Gio. This is where he talks to
I'm pretty sure I woke up early in the morning and looked at my phone and was seeing like your little phone on my phone and just like
What time is that?
I'm not, it was like probably like a little before I woke up. I woke up at 6 o'clock. I woke up, I had to go to the bathroom, I looked at the phone, I think I checked her Snapchat to see if there's anything on there. So she got a snap from somebody and I put my phone down and I checked it and
Did you tell him that?
There's two problems with what he told the police officers at that time. He did not get up in the morning and check her Snapchat account. The morning check was at 6:40 a.m. when the search for his son was beginning, number one. And number two, he says, I checked her Snapchat account and saw she got a message, I ignored it. Highly unlikely. This guy doesn't ignore anything. This is where he speaks to the officers about his jealousy.
So you met Julie on Tinder?
yes,
Okay. And she's 17?
yes.
Okay. And you were concerned that maybe she was seeing somebody else?
I think it's just she's just been talking to a guy at a friend at school and I just been getting jealous about it. But
Did she send it to you, or how did you find it out?
because she's brought the guy up and I was like, reading for myself, so he asked her if someone help in class and he asked her to take her out for lunch and she said no, I have a boyfriend, and then I know they still talk in class, I was just being jealous.
Okay, so she told you to ask me out for lunch?
Yeah, and she said she's saying no.
Did she make it sound like a date, or just like casual?
No, just like he went to buy her lunch for helping him with the homework assignment, and then
In the next clip, he tells a big lie about Sam.
yeah, I even saw how hard it was on Brendan being Sam being broken up. That's why you take into consideration getting back with it for him.
It's not what he said in his text. What he said in his text is, no, I don't talk to her. I don't talk to her when I have to if it was up to me. Let me repeat that. No, I don't talk to her when I have to if it was up to me. I'd never say or talk to her again. And fine, I won't talk to her when she drops him off. I'll just grab him. We don't talk on the phone. You asked me not to a while ago, and now we don't. And we don't have conversations just when you're getting him. That's it. We don't talk, WTF. We literally don't even conversation at all. We don't talk. I'll delete her number and just tell my mom to text her if that's what you want, Julie. He's going to get back together with her because it's hard on Brendan. Because here he says he wants to move far away from here and get a lawyer and see what his options are. He's really been thinking about it. Not only does he tell a lie about Sam, he tells a lie to Sam on the consensual.
He literally, like, my whole life was based around him. I did everything for him. Like, I worked and had a apartment for him and, like, made sure, like, I don't know, like, I was trying to work extra hard to make sure I had the money for his daycare. I was just doing everything.
I had the apartment for him. Well, sure, because here's your nice snuggly bed for you to sleep in at night. And here's all the good stuff for you to eat and drink. I mean, as long as you like craft beer, right? I had the apartment for him. Of the 10,000 texts that went back and forth between him and Julie, of all the horrible things that they said to each other, of all the mean, nasty, foul-mouthed, whatever you want to call it, of those texts, it's actually 1,487. That one is the most heartbreaking. That is the one that tells you what kind of father he is. You're still, come see me, Julie. You're still spending time with me. He sits in the other room. That is heartbreaking. That a 3-year-old child would be stuck sitting in another room so that guy can hang out with a 17-year-old girlfriend. That is heartbreaking. That's what kind of father he is. That's all you need to know about him. He was trying to work extra hard to make sure he had money for his daycare. That comes from the consensual. No, he wasn't. This is from that Friday. Don't come to my apartment when you're here. Do not come to my apartment. Go towards Cooper, and I'll get you. I'll explain. I'm sorry, this was the previous weekend. She says, tell me why now. He says, because I had to lie to my dad to be able to be home early, and he's here fixing my bed. If he sees you, he'll know I'm lying. That's not a huge deal because he lied to his dad. The lie to his father is so significant because if you recall, part of the reason that the defendant was having such terrible financial trouble is because he wasn't getting paid on time. He works for his dad. It is a family business, and it is failing. It's his father's livelihood. It's his livelihood. But if Julie's coming to town, he's going to get out of work early. He's not going to help his dad run that business or make ends meet. So for him to say, I was trying to work extra hard to make sure I had money for his daycare, it's just ridiculous. And he tells all these lies because he wants to make himself look like a better father than he actually is. He's really just a fraud. He didn't do anything for that child. And I'm not saying that he didn't love him. I'm sure that he did love him in his own way, okay? But he loved himself more. And he definitely loved Julie more. And that is evident in every single aspect of his life. His house, his job, his communications, how he spends his time. So how did this all work out for the defendant? Let's look at a little bit of the aftermath here. October 17th, it's Saturday. Brendan just had his third autopsy the day before his body's still at the morgue. This is hard to read. I have to go a little bit closer to it. This is a screenshot off of his phone of a saved Snapchat between Julie and Gio. Notice I'm talking to two different people on Snapchat. LOL, who are you talking to that you effed? My boyfriend. Oh, well, that makes sense. Possibly you making out with another girl, and she says, did you like my boobs? And he says, ha, 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 yeah. That's the Saturday after his son's dead. That's what he's doing. He's still in her accounts, wanting to know what's going on. October 28th, Mr. Fushino's right. They did go to New York. He did go to New York City. Right? That's the Freedom Tower, I believe. It's right down near the campus where Pace University is. And of course, there's a picture of the squirrel because he's a nature lover. That picture could have been taken in New York. It could have been taken at Cooper River. It probably could have been taken in a lot of people's backyards. But there it is in New York City. About October 30th, Haddon Township. This is taken at the defendant's parents' house. Happy family. Right? Get him, get the girlfriend, get the hedgehog. Do you remember the fight that they were having about Halloween? And he said, I need to take Brendan trick-or-treating. And she's like, well, I'm going to go to a party. And, you know. He says to Julie, how is she supposed to? I only have him for like a half hour of trick-or-treating, which I don't have to do. If you get him every other weekend, you should not have him at all on Halloween weekend. He says that I don't have him. Halloween is awesome this year. It's nothing but fun and costumes, and I want to be the Hulk, or I want to be Spider-Man. There's no gift obligations. There's no meal obligations. Halloween's just fun. He'd rather spend it with her. He did. Because that's what was counted from Halloween. Again, taken to his parents' house. When he talked to Sam on the consensual, and he was talking about how things were different, and he said things like, oh, I don't really, I don't go out of the house now, I hardly do that. Really, he's had more travels in the last 2 weeks than he probably has in the entire previous year. So that was a lot. But this is the thing that was so upsetting that he said. After he said that he was upset because there were so many It's the way that he phrases things that's so odd and unusual. He's like, I had so much more experiencing that I wanted to do with it. It's just an odd statement, because somehow or another, he's still the main subject. You know what I'm saying? It's all about him. And this is how he feels about it. Now that Brendan's gone. It's hard to hear. I feel like I have so many options now. He said that to Sam. He said that to Brendan's mother. Good light. Now, the argument was made that the defendant knew that he could leave. That he could leave Brendan with his family, certainly his family, the defendant's parents absolutely would have taken Brendan in. They had done that before. He could walk away from him, and after all, he had done that before. He did it just the summer before. But you know what, this time it's different. He can't do it again. This time he doesn't want to go too far because Julie's just right in New York City. He doesn't want to go too far from her. And this time he has no money. He can't even pay for daycare. He's got $30 to get him to the end of the week. His car died. He doesn't have a way to get anywhere. So tell me, where's he going to go? Make no mistake about it. He's stuck right where he is. He has no money. And he has no freedom, and he has no reason to think that either of those two things will change anytime soon. The only bright spot in his life is a teenager named Julie, and he thinks he's going to lose her too. Smuggling Brendan solved every single one of his problems. Everything. I'm going to talk to you a little bit about what it means to prove something, excuse me, beyond a reasonable doubt. For once in the law, the definition of it is actually quite simple. It's two words, and those words are firmly convinced. In order to find something beyond a reasonable doubt, you have to be firmly convinced. The law recognizes that in this world, we know very few things with absolute certainty. And that is why, under the law, you may convict a person of a crime, even if you have some doubts. They just can't be reasonable doubts. And there is no reasonable doubt in this case. You should convict this defendant of killing his son, because every single thing in this case, every piece of evidence, points to him. He had the motive, he had the opportunity, he certainly had the means. And he is the only person on this entire earth whose life is better than Brendan. He is not the victim in this case. He is the killer.
Thank you, Counsel. Mr. Drew, we're going to take just a brief break before I get charged. My charge is just let you stretch your legs. Again, to discuss the case, it's just going to be a 10-minute break, and we'll get you back in here. I'll read you my charge, and then your responsibility will begin.
Please rise.
Great, please be seated.
Excuse me.
He'll probably get charged and go home this hour, don't you think?
Describes the evidence that you may consider in your deliberations. The third part is about the portions of the Criminal Code of New Jersey, because you must apply to the facts you find in this case to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. Finally, the fourth part of the instructions tells you how to go about conducting your deliberations. You must accept and apply this law for this case as I give it to you in this charge. And Any ideas you have of what the law is or what the law should be, or any statements by the attorneys as to what the law may be, must be disregarded by you if they are in conflict with my charge. Now, beginning with the general principles of law that apply to a criminal case, the defendant stands before you on an indictment returned by a jury charging him with, in count 1, murder, and count 2, endangering the welfare of a child. The indictment is not evidence of the defendant's guilt on the charges. An indictment is a step in the procedure to bring the matter before the court and jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty on the charges stated in it. The defendant has pled not guilty to the charges. The defendant on trial is presumed to be innocent, and unless each and every essential element of an offense charged is proved beyond a reasonable doubt, the defendant must be found not guilty of that charge. The burden of proving each element of a charge beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. The defendant in a criminal case has no obligation or duty to prove his innocence or to offer any proof relating to his innocence. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt, honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence. A reasonable doubt may arise from the evidence itself or from a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. The function of the judge is separate and distinct from the function of the jury. It is my responsibility to determine all questions of law arising during the trial and to instruct the jury as to the law which applies in this case. You must accept the laws given to you by me and apply it to the facts as you find them to be. During the course of the trial, I was required to make certain rulings on the admissibility of the evidence either in or outside of your presence. These rulings involved questions of law. The comments of the attorneys on these matters were not evidence. In ruling, I have decided questions of law, and whatever the ruling may have been in any particular instance, you should understand that it was not an expression or opinion by me on the merits of the case. Neither should my other rulings on any other aspect of the trial be taken as favoring one side or the other. Each matter was decided on its own merits. I may have sustained objections to some questions asked by counsel which may have contained statements of certain facts. The mere fact that an attorney asks a question and inserts facts or comments or opinions in that question in no way proves the existence of those facts. You will only consider such facts which in your judgment have been proven by the testimony of witnesses or from exhibits admitted into evidence by the court. The fact that I may have asked questions of witness in the case must not influence you in any way in your deliberations. The fact that I ask such questions does not indicate that I hold any opinion one way or the other as to the testimony given by the witness. Any remarks made by me to counsel or by counsel to me or between counsel are not evidence and should not affect or play any part in your deliberations. As I instructed you when we started this case, I explained to you that you are the judges of the facts, and as judges of the facts, you are to determine the credibility of the various witnesses as well as the weight to be attached to their testimony. You and you alone are the sole and exclusive judges of the evidence, of the credibility of the witnesses, and the weight to be attached to the testimony of each witness. Regardless of what counsel said or I may have said recalling the evidence in this case, it is your recollection of the evidence that should guide you as judges of the facts. Arguments, statements, remarks, openings, and summations of counsel are not evidence and must not be treated as evidence. Although the attorneys may point out what they think important in this case, you must rely solely upon your understanding and recollection of the evidence that was admitted during the trial. Whether or not the defendant has been proven guilty beyond a reasonable doubt is for you to determine based on all of the evidence presented during the trial. Any comments by counsel are not controlling. It It is your sworn duty to arrive at a just conclusion after considering all the evidence which was presented during the course of the trial. Now I will move on to the second part of the instructions and discuss the evidence that you may consider judging the facts of the case. When I use the term evidence, I mean the testimony you've heard and seen from the witness box, any stipulations and the exhibits which have been admitted into evidence. Any exhibit that has not been admitted into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items admitted into evidence can be given to you. Any testimony that I may have had occasion to strike is not evidence and shall not enter into your final deliberations. It must be disregarded by you. This means that even though you may remember the testimony, you're not to use it in your discussions or deliberations. Further, if I gave a limiting instruction as to how to use certain evidence, that evidence must be considered by you for that purpose only. You cannot use it for any other purpose. As jurors, it is your duty to weigh the evidence calmly and without passion, prejudice, or sympathy. Any influence caused by these emotions has the potential to deprive both the state and the defendant of what you promised them, a fair and impartial trial by fair and impartial jurors. Also, speculation, conjecture, and other forms of guessing play no role in the performance of your duty. As I instructed you at the beginning of the case, evidence may be either direct or circumstantial. Direct evidence means evidence that directly proves a fact without an inference and which in itself, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. Whether or not inferences should be drawn is for you to decide using your own common sense, knowledge, and everyday experience. Ask yourselves, is it probable, logical, and reasonable? It is not necessary that all the facts be proven by direct evidence. They may be proven by direct evidence, circumstantial evidence, or by a combination of direct and circumstantial evidence. All are acceptable as means of proof. In many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. However, direct and circumstantial evidence should be scrutinized and evaluated carefully. A verdict of guilty may be based on direct evidence alone, circumstantial evidence alone, or a combination of direct evidence and circumstantial evidence, provided, of course, that it convinces you of a defendant's guilt beyond a reasonable doubt. The reverse is also true. A defendant may be found not guilty by reason of direct evidence, circumstantial evidence, a combination of the two, or a lack of evidence, if it raises in your mind a reasonable doubt as to the defendant's guilt. As the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take into consideration the appearance and demeanor of the witness, the manner in which he or she may have testified, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning his or her judgment or understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the side for whom the witness testified, the extent to which, if at all, each witness is either corroborated or contradicted, supported or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony the witness has given, whether the witness made any inconsistent or contradictory statement, and any and all other matters in the evidence which serve to support or discredit his or her testimony. Through this analysis, as the judges of the facts, you are to weigh the testimony of each witness and then determine the weight to give to it. Through that process, you may accept all of it, a portion of it, or none of it. Evidence of good character or reputation of an accused is always competent in the trial of criminal action and is entitled to be considered by you. You, the jury, should consider all of the relevant testimony, including that relating to the defendant's good character or reputation, and if on such consideration there exists a reasonable doubt of his guilt, even though that doubt may arise merely from his or her previous good repute, he is entitled to an acquittal. But if, from the entire evidence in this case, including that relating to good character, you believe the defendant guilty beyond a reasonable doubt, he should be convicted, and the evidence of good character should not alter that verdict. As you know, David Creato elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose in your manner or in any manner in arriving at your verdict the fact that David Creato did not testify. That fact should not enter into your deliberations or discussions in any manner at any time. David Creato is entitled to have the jury consider all evidence presented at trial. He is presumed innocent whether or not he chooses to testify. As a general rule, witnesses can testify only as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert witness who may give his or her opinion as to any matter in which he or she is versed, which is material to the case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and determining the facts of the case. In this case, Dr. Gerald Feigen, an expert in anatomical pathology, clinical pathology, and forensic pathology; William Shute, an expert in historic cell site analysis; Tina Kniper, an expert in biological stain analysis and forensic serology; Jennifer Benag, an expert in nuclear DNA analysis; Dr. Charles Siebert, an expert in anatomical pathology and forensic pathology; and Dr. Andrew Falzone, an expert in anatomical pathology, clinical pathology, and forensic pathology; and Louis Cinquanto, an expert in digital forensic analysis, were called as experts. You're not bound by such experts' opinion, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight. Or you may reject it. In examining each opinion, you may consider the reasons given for it, if any. You may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon, and is no stronger than, the facts on which it is based. In other words, the probative value of the opinion will depend upon whether, from all the evidence in the case, you find that those facts are true. You may, in fact, determine from the evidence in the case that the facts that form the basis of the opinion are true, are not true, or are true in part only. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. The ultimate determination of whether the state has proven defendant's guilt beyond a reasonable doubt is to be made only by the jury. The parties have agreed to certain facts. The jury should treat these facts as undisputed. That is, the parties agree that these facts are true. As with all evidence, undisputed facts can be accepted or rejected by the jury in reaching a verdict. There is, for your consideration in this case, a recorded statement allegedly made by the defendant. It is your function to determine whether or not the statement was actually made by the defendant, and if made, whether the statement or any portion of it is credible. You may consider all the circumstances surrounding the statement in making the determination with the following caution. I instruct you that in this case certain portions of the recorded statement have not been provided to you. You may only consider those portions of the statement which have been admitted in evidence, and must not speculate as to the contents of the omission or the reason or reasons for the omissions. Now I will instruct you in the third part of the instructions on the portion of the criminal code that you must apply to the facts you find to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. The statute, read together with the indictment, identifies the elements to which the state must prove beyond a reasonable doubt to establish the guilt of the defendant on the count in the indictment. The defendant is charged by indictment with the murder of Brendan Creato. Count 1 of the indictment reads as follows: that on or about the 13th day of October 2015 in the township of Haddon in the county of Camden aforesaid, and within the jurisdiction of the court, did purposefully or knowingly cause the death or serious bodily injury resulting in the death of B.C., date of birth June 1st, 2012, contrary to the provisions of our statutes, and against the peace of this state, the government, and dignity of the same. A person is guilty of murder if he, 1, caused the victim's death or serious bodily injury that then resulted in death, and 2, the defendant did so purposefully or knowingly. In order for you to find the defendant guilty of murder, the state is required to prove each of the following elements beyond a reasonable doubt. Number 1, that the defendant caused Brendan Creato's death or serious bodily injury that resulted in Brendan Creato's death, and 2, that the defendant did so purposefully or knowingly. One of the elements that the state must prove beyond a reasonable doubt is that the defendant acted purposefully or knowingly. A person acts purposefully when it is the person's conscious object to cause death or serious bodily injury resulting in death. A person acts knowingly when the person is aware that it is practically certain that his conduct will cause death or serious bodily injury resulting in death. The nature of the purpose or knowledge with which defendant acted towards Brendan Creato is a question of fact for you, the jury, to decide. Purpose and knowledge are conditions of the mind which cannot be seen and can only be determined by inference from conduct, words, or acts. It is not necessary for the state to produce a witness or witnesses who could testify that the defendant stated, for example, that his purpose was to cause the death or serious bodily injury resulting in death, or that he knew that his conduct would cause death or serious bodily injury resulting in death. It is within your power to find that proof of purpose or knowledge has been furnished beyond a reasonable doubt by inferences which may arise from the nature of the acts and the surrounding circumstances. Such things as the place where the acts occurred, the weapon used, the location, number, and nature of wounds inflicted, and all that was done or said by the defendant preceding, connected with, and immediately succeeding the events leading to the death of Brendan Creato are among the circumstances to be considered. Although the state must prove the defendant acted either purposefully or knowingly, the state is not required to prove a motive. If the state has proved the essential elements of the offense beyond a reasonable doubt, the defendant must be found guilty of that offense regardless of the defendant's motive or lack of motive. If the state, however, has provided a motive, you may consider that insofar as it gives meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether or not the defendant is guilty of the crime charged. The other element the state must prove beyond a reasonable doubt is that the defendant caused Brendan Creato's death or serious bodily injury that then resulted in death. As I previously advised you, in order to convict defendant of murder, the state must prove beyond a reasonable doubt that the defendant either purposely or knowingly caused the victim's death or serious bodily injury resulting in death. In that regard, serious bodily injury means bodily injury that creates a substantial risk of death. A substantial risk of death exists where it is highly probable that the injury will result in death. In order for you to find the defendant guilty of purposeful, serious bodily injury murder, the state must prove beyond a reasonable doubt that the defendant's conscious object was to cause serious bodily injury that then resulted in the victim's death, that the defendant knew that the injury created a substantial risk of death, and that it was highly probable that death would result. In order for you to find a defendant guilty of knowing serious bodily injury murder, the state must prove beyond a reasonable doubt that the defendant was aware that it was practically certain that his conduct would cause serious bodily injury that then resulted in the victim's death, that the defendant knew that the injury created a substantial risk of death, and that it was highly probable that death would result. Whether the killing is committed purposely or knowingly, causing death or serious bodily injury resulting in death, must be within the design or contemplation of the defendant. In order for you to find the defendant guilty of murder, the state must first establish beyond a reasonable doubt that the defendant caused Brendan Creato's death or serious bodily injury resulting in death, either purposely or knowingly, as I have defined these terms for you. The state, however, is not required to prove a motive. If the state has proved the essential elements of the offense charged, the offense beyond a reasonable doubt, the defendant must be found guilty of that offense regardless of the defendant's motive or lack of motive. If the state, however, has proved the motive, you may consider that insofar as it gives meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether or not the defendant is guilty of the crime charged. All jurors do not have to agree unanimously concerning which form of murder is present, so long as it is believed that one form of murder or the other. However, for a defendant to be guilty of murder, all jurors must agree that the defendant either knowingly or purposely caused the death or serious bodily injury resulting in the death of Brendan Creato. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant either purposefully or knowingly caused Brendan Creato's death or serious bodily injury resulting in death, then your verdict must be guilty. If, however, after consideration of all the evidence, you find the state has failed to prove any element of the offense beyond a reasonable doubt, your verdict must be not guilty. Defendant is charged with endangering the welfare of a child. Count 2 of the indictment reads that on or about the 13th day of October 2015 in the township of Haddon, the county of Camden aforesaid, and within the jurisdiction of the court, having legal duty for the care of BC, age 3, born June 1st, 2012, or having assumed responsibility for the care of BC, did knowingly cause harm to said child, which would make the child an abused or neglected child, contrary to the provisions of our statute, against the peace of this state, the government, and dignity of the state. The statute upon which this charge is based reads in pertinent part, any person having a legal duty for the care of a child, or who has assumed responsibility for the care of a child, who causes the child harm that would make the child an abused or neglected child, is guilty of a crime. To find David Creato guilty of this crime, the state must prove beyond a reasonable doubt these elements. Number one, that Brendan Creato was a child. Number two, that the defendant knowingly caused the child harm that would make the child abused or neglected. Number three, that the defendant knew that such conduct would cause the child harm that would make the child abused or neglected. And four, that the defendant has a legal duty for the care of the child or had assumed responsibility for the care of the child. The first element the state must prove beyond a reasonable doubt is that Brendan Creato was a child. The child means any person under the age of 18 years at the time of the offense. The state must prove only the age of Brendan Creato at the time of the offense beyond a reasonable doubt. Does not have to prove the defendant knew or reasonably should have known that Brendan Creato was under the age of 18. The second element the state must prove beyond a reasonable doubt is that the defendant knowingly caused the child harm that would make the child abused or neglected. An abused or neglected child means, one, that the defendant inflicted or allowed to be inflicted upon such child physical injury by other than accidental means which causes or creates a substantial risk of death or serious or protracted disfigurement or protracted impairment of physical or emotional health or a protracted loss of or impairment of the function of any bodily organ, or two, that the defendant created or allowed to be created a substantial or ongoing risk of physical injury to such child by other than accidental means which would be likely to cause death or serious or protracted disfigurement or protracted loss or impairment of the function of any bodily organ. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that the conduct is of that nature or that such circumstances exist, or that the person is aware of the high probability of their existence. A person acts knowingly with respect to a result of his conduct if he is aware that it is practically certain that such conduct will cause a result. Knowing with knowledge or equivalent terms have the same meaning. Knowledge is a condition of the mind. It cannot be seen. It can only be determined by inference from David Creato's conduct, words, or acts. A state of mind is rarely susceptible of direct proof, but must ordinarily be inferred from the facts. Therefore, it is not necessary that the state produce witnesses to testify that an accused said that he had a certain state of mind when he did a particular thing. It is within your power to find that such proof has been furnished beyond a reasonable doubt by inference, which may arise from the nature of his acts and conduct, and from all he said and did at that particular time and place, and from all the surrounding circumstances established by the evidence. The third element the state must prove beyond a reasonable doubt is that the defendant knew that his conduct would cause the child harm that would make the child abused or neglected. I have previously defined the concept of knowing for you. The fourth element the state must prove beyond a reasonable doubt is that the defendant had a legal duty for the care of the child or assumed responsibility for the care of the child. A person having a legal duty for the care of a child or who has assumed responsibility for the care of a child includes a natural parent, adoptive parent, resource family parent, step-parent, or any other person who has assumed responsibility for the care, custody, or control of a child, or upon whom there is a legal duty for such care. A person who has assumed the responsibility for the care of the child includes any person who assumes a general and ongoing responsibility for the child and to establish a continuing or regular supervisory or caretaker relationship with the child. The general and ongoing responsibility for the care of the child that may be a legal and formal, or it may arise from informal arrangements. It may be based not only on a parental relationship or a legal custody, but also on a less structured relationship, such as cohabitation with the parent of the child. In determining the nature of the relationship between the defendant and the child, you should consider these factors: the disparity in age or maturity, the importance of the activity or activities the adult supervises to the child, the extent of the supervising relationship beyond the guidance and advice expected given the adult's supervising role, and the degree of dependence and the trust the child places in the adult. If the state has proven every element of the offense beyond a reasonable doubt, then you must find the defendant guilty of endangering the welfare of a child. If the state has failed to prove any of the elements of the offense beyond a reasonable doubt, then you must find the defendant not guilty. I will now give you some information on the final part of these instructions on conducting your deliberations. There's nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense, consider the evidence for only those purposes for which it has been admitted, and give it a reasonable and fair construction in the light of your knowledge of how people behave. It is the quality of the evidence, not simply the number of witnesses that control. As I said before, any exhibit that has not been marked into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items marked in evidence can be given to you. Very shortly, you will go into the jury room to start your deliberations. I remind you that during deliberations, and in fact, any time you're in the jury deliberation room, you must keep any cell phone, pager, or other communication device you may possess turned off. You are to apply the laws I've instructed you to the facts as you find them to be, for the purpose of arriving at a fair and correct verdict. The verdict must represent the considered judgment of each juror and must be unanimous as to each charge. This means all of you must agree if the defendant is guilty or not guilty on each charge. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourselves, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You are not partisans, you are judges of the facts. You may return on each crime charge the verdict of either guilty or not guilty. Your verdict, whatever it may be, as to each crime charge must be unanimous. Each of the 12 members of the deliberating jury must agree as to the verdict. To assist you in reporting the verdict, I have prepared a verdict sheet for you. You will have this in the jury room. This verdict form is not evidence. The form is only to be used to report your verdict. And the verdict form is quite simple. It's 2 pages. The first page sets forth the crime of murder, sets forth the elements of the crime, and then your verdict would be reported as either not guilty or guilty. Your foreperson would check off the determined verdict. The second count is then set forth on the second page regarding the charge of endangering the welfare of a child. Again, you would report your verdict as not guilty or guilty. After both counts have been spoken to by the jury, the foreperson would then sign and date it, and then it would be reported that you have a verdict. Jury, if during your deliberations you have a question or feel you need further assistance or instructions from me, or wish to have certain testimony read or played back, or video or audio exhibits played back, write your question or request on a sheet of paper and give it to the sheriff's officer, who will be standing at the jury room door, who in turn will give it to me. The court officer will be sworn to perform certain duties, such as keeping the jury together in a private place for purposes of deliberations and ensuring that no one speaks with you except by order of the court. You're not to discuss with or ask the officer about trial matters or procedures. Please be aware that the officer is also instructed not to initiate communications with you or to enter the deliberation room without your consent, except to communicate on my behalf regarding administrative matters, such as information about breaks or meals, or otherwise to ensure your comfort. If the officer must enter the deliberation room, the officer will knock first and complete the officer's responsibilities without delay. When the officer enters the room, please stop your deliberations and do not resume until the officer has left and the door is closed. Once I receive your question or request, I will go over it with the lawyers, and we will answer it as quickly as possible. Please be patient. If you do send out a question, do not disclose where you stand in your deliberations. Do not tell us, for example, that you are 10 to 2 or 8 to 4 on any given charge. If you have reached a unanimous verdict on each charge, knock on the door and let the officer know that, and you will be brought into the court as soon as possible to receive your verdict. I have now come to the end of my charge. I have been reading these legal instructions to you. I will give you a written copy of the same instructions for your use in the jury deliberation. Be aware that you must consider these instructions in their entirety, and I am available to assist in understanding the instructions if you need further assistance. Also, do not rely on the subheadings in the written instructions. They do not add to any explanations I have given at greater length. Their only purpose is to help you and me and the parties find the appropriate topics covered by the instructions. May I see Counsel Semper? Now we come to the hard argument. We are going to reduce the jury to 12. Alternates will be selected at random.
Alternate number 1 is in C, number 11. Number 11.
No, number 11 here. No, 11, right?
Yeah.
11. Have to do that occasionally. Yeah, I'm going to ask you to step down and just have one of the seats in those wheelchairs. Okay.
Alternate number 2 is in C, number 4.
As to the alternates, you're not excused as jurors. You will be kept in a separate location in case it becomes necessary to substitute one or both of you for another juror or jurors. You should not therefore discuss the case with anyone or between the two of you. If it becomes necessary to substitute an alternate, I will give you and the remaining deliberating jurors further instructions of law at that time. If there is a question or a verdict, you will be brought back into the court so that you may hear it. Juror number 1. You are the foreperson of the jury because of your position in the jury box. You will preside over the deliberations and tell us the verdict when reached. Your vote carries no greater weight than that of any of the other deliberating jurors. It is your responsibility to lead deliberations. It is also your responsibility to tell us what the verdict is when the jury has reached it. When you come out with your verdict, please resume the seats you now have. We will make certain everyone is here. We will then ask the foreperson to stand and confirm that you have arrived at a verdict. We will read each charge and will ask the foreperson what the verdict is as to each. The foreperson will answer with the verdict on each charge. We will then poll each of the deliberating jurors to confirm his or her agreement with the verdict announced by the foreperson. As soon as the officer is sworn, you will proceed to the jury room. You're not to begin your deliberations until the jury verdict form and the exhibits will be delivered to you. They will be delivered shortly. With that, I'd ask that the officer come forward to be sworn.
Sticking in threaten, please. Do you swear or affirm that you would do your best to keep every person sworn on this jury together in a private place, and that you will not allow any person to speak to them or speak to them yourself, except by the order of the court, and except to ask them if they have agreed on a verdict until they have so agreed?
Members of the jury, your responsibilities now begin.
Please rise. Alternates come forward. You'll be sitting separate.
the rest of it. You can have a seat. We're going to stand in recess. I have to do another matter. I'm going to let them deliberate till quarter after. We'll bring them back. I'm looking at the time now. Let me bring the exhibition in. Yeah. I'm going to have to ask everyone to leave because we have to bring another matter. I have to take care of an exhibition here. I was asked to make an announcement that photos should not be taken in the courthouse of the family, other than in the courtroom, because that's the permission that was given. I was asked to say that. Thank you very much. And thank you for everyone for your cooperation in the course of the trial. Can you bring the jury around?
What time are you going on to? Judge 9?
Approximately 9 on the bell. Hopefully nobody have traffic problems tomorrow.
Please rise.
Please be seated. Welcome back, members of the jury. As you recall, when we started the trial, I indicated our court day aims to close at 4 o'clock. I went a little bit longer today because I thought it would be helpful just to get everybody together to start responsibilities. There's one thing I didn't mention, I just want to mention now, with reference to the evidence. The evidence has been sent back. Obviously, some of the evidence is in formatted that either had to be played or viewed. If you desire to look at that again, you have to come into the court. Under the rules of the court, you cannot provide video cameras or video equipment in the jury deliberation. So certainly if you want to hear or see anything again, it's in the form of an audio or video disc, just let us know and we can make that arrangement for you. Members of the jury, we will now recess for the day. You must cease your deliberations until you return tomorrow morning at 9 o'clock. I instruct you to resume, and at that time I will instruct you to resume your deliberations in accordance with the instructions I've previously given to you. In addition, I must now remind you of my previous instructions. You must not discuss the case among yourselves with yourselves or with anyone else. You must not discuss the case with your fellow jurors until you return and are instructed by me to resume your deliberations. You must not communicate with anyone about this case, either in person or telephonically, or through any electronic means, such as texting, emailing, tweeting, or on Facebook or any other social media. If anyone attempts to communicate with you about the case or discuss the case with you, do not discuss it with your fellow jurors. Please report the matter to me immediately, and I will deal with the situation promptly. You must not read or have anyone read to you any newspaper, news story, articles about the case in print, on the internet, or any blog, or in any other media. You must not read, listen, or watch to any media accounts or coverage of the case, and do not listen to anyone else discuss such accounts. You must not read, research, or investigate anything about the case or any persons, places, or topics related to the case. This prohibition applies to printed reference materials as well as to any electronic medium, and includes searching the internet for blogs, tweets, Facebook, or any other social media. When you return tomorrow morning, do not commence your deliberations until you're instructed to do so by me. When you do return, you'll report as you've done in the past, and once we have all 12 jurors, deliberating jurors, we'll bring you into the courtroom, and then you'll be sent out for your responsibilities. You shall only discuss and deliberate the case when all the jurors are together in the jury room, and that you've been directed to resume your deliberations by me. The reason we give this instruction at the end of the day, the deliberative process is that it's when all 12 jurors are together and deliberating. So tomorrow morning, if one or two of you see each other on the high-speed line, or you get here earlier, talk about the Phillies, talk about the weather, don't discuss the case until all 12 jurors are together, and then the deliberative process begins. And with that, I wish everyone a very pleasant evening. I ask you to be here promptly at 9 o'clock tomorrow. The alternates can bring a good book to read. If we need your service, obviously we have to ask that you be here. But with that, I wish everyone a pleasant evening.
Please rise.